that state law currently requires that the following announcement be made at the beginning of every remote public hearing as follows. Due to the current public health emergency, City Council committees are currently meeting remotely. We are using Microsoft Teams to make these remote hearings possible. Instructions for how the public may view and offer public testimony at public hearings of council committees are included in the public hearing notices that are published in the Daily News, Inquirer, and Legal Intelligencer prior to the hearings, and can also be found on PHL. I now note that the hour has come. Rachel, will you please call the roll to take attendance? Members that are in attendance will please indicate that you are present when your name is called. Also, please say a few brief words when responding so that your image will be displayed on the screen when you speak.
Councilmember Derek Green.
I'm present, looking forward for today's hearing today.
Councilmember David O.
Yes, I'm here having technical difficulties. I hope everyone can hear me. Thank you.
We can hear you, Councilman.
Councilmember Helen Gim.
I'm going to be on.
Present, and thank you very much, Madam Chair, for all the hard work, and to your team for all the hard work you put into this.
Thank you.
Councilmember Curtis Jones Jr.
Good afternoon, everyone. If you hear a little background laughter, in spite of pandemics and uprisings, young grandkids graduate, so they're in the background.
We understand, Councilman.
Councilmember Brian O'Neill.
Congratulations, Grandpa. Present.
Councilmember Cindy Bass.
Good afternoon. Thank you so much. I am present, and congratulations, Councilman Jones.
Councilmember Maria Sanchez.
Good afternoon, everyone. I am here.
Councilmember Mark Squilla.
Hello, I'm here, present. Looking forward to the hearing.
And Councilmember Kenyatta Johnson may be joining since his bill is being heard, although he's not a member of the committee.
I'm here.
Thank you, Councilmember Jones. Rachel, have you completed the roll call?
Excuse me, Madam Chair.
Yes.
Councilman Johnson, you called me Jones?
John, this is the second time I've done that, Councilman Johnson.
You did. You did. It's okay, Madam Chair.
Thank you. This is the public hearing of the Committee on Law and Government regarding bill numbers 200076, 200208, and 200328, and resolution numbers 200080 and 200216. Will you please read the titles of the bills and resolutions, Rachel?
200076, an ordinance providing for the submission to the qualified electors of the City of Philadelphia of an amendment to the Philadelphia Home Rule Charter, calling on the police department to eliminate the practice of unconstitutional stop and frisk, as approved by resolution of the City Council, fixing the date of a special election for such purpose, prescribing the form of ballot question to be voted on, and authorizing the appropriate officers to publish notice and to make arrangements for the special election. 200208, an ordinance providing for the submission to the qualified electors of the City of Philadelphia of an amendment to the Philadelphia Home Rule Charter, providing for the creation of the Office of the Victim Advocate, as approved by resolution of the City Council, fixing the date of a special election for such purpose, prescribing the form of ballot question to be voted on, and authorizing the appropriate officers to publish notice and to make arrangements for the special election. 200328, an ordinance amending the Philadelphia Code to add a new chapter entitled Employee Protections in Connection with COVID-19 Emergency Health Order, to provide workplace protections in emergency health orders and regulations, provide protections for employees against retaliatory actions, both for the disclosure of information related to employer noncompliance with such orders and for the refusal to work under unsafe conditions caused by noncompliance with such orders, all under certain terms and conditions. 200080, resolution proposing an amendment to the Philadelphia Home Rule Charter calling on the police department to eliminate the practice of unconstitutional stop and frisk and providing for the submission of the proposed amendment to the electors of Philadelphia. And 200216, resolution proposing an amendment to the Philadelphia Home Rule Charter providing for the creation of the Office of the Victim Advocate and providing for the submission of the amendment to the electors of Philadelphia.
Thank you, Rachel. Before we begin to hear testimony from the witnesses we have for today, everyone who has been invited to the meeting to testify should be aware that this public hearing is being recorded. Because the public hearing is being recorded, participants and viewers have no reasonable expectation of privacy. By continuing to be in the meeting, you are consenting to being recorded. Additionally, prior to recognizing members for questions or comments they have for witnesses, I will note for the record at this time that we will use the chat feature available in Microsoft Teams to allow members to signify that they wish to be recognized in order to comply fully with the Sunshine Act. The chat feature must only be used for this purpose. Before I ask Rachel to call the first panel for the bill number 200076 and resolution number 200080, I would like to make some opening comments. Because authenticity matters to me, let me note for the record that I am the mother of a 7-year-old black boy who, between the ages of 5 and 6, asked if he could get his hair locked, not as any kind of political or cultural statement, but simply because he wanted his hair to be like his father's hair. A 7-year-old black boy who, when he becomes of age to travel and live on his own, he won't have the luxury or privilege of being able to wear his race and ethnicity during times of convenience or when it suits a particular audience or environment. You see, his skin, like mine, has been what my grandmother says, kissed by the sun, referring to the melanin in our skin and our dark hues. Knowing that the aforementioned is an undeniable truth, and that because of it, black people, black men in particular, and other people of color are almost certain to be stopped and frisked by police without a reasonable suspicion is more than unnerving. In fact, it is unconstitutional. I provide this context because I want my colleagues, all of them, for whom I have a great deal of respect, to know that when I proposed this ballot question, it was done before the COVID-19 global pandemic and before the global movement against police brutality and systemic racism began permeating through communities across the world. As a matter of fact, it was on January the 30th that I introduced legislation that would put the following question on the ballot. Shall the Philadelphia Home Rule Charter be amended to call on the police department to eliminate the practice of unconstitutional stop and frisk consistent with judicial precedent, meaning an officer must have reasonable suspicion that a person is engaged in criminal activity in order to stop that person, and therefore an officer cannot stop someone unlawfully because of their race, ethnicity, gender, sexuality, religious affiliation or expression, or other protected characteristic. Considering what has happened between now and January 30th, it feels like I introduced this legislation a lifetime ago. As we all know, the recent inhumane killing of George Floyd at the hands of the police has shown a glaring light on our modern day police tactics and the overwhelmingly negative impacts they have on Black people and other people of color. Now, for the record and the benefit of the public, I want to clarify what I mean when you hear me describe stop and frisk. I want to clarify that when we refer to stop and frisk throughout the course of this hearing, we are predominantly referring to its legal definition as determined by legislation and subsequent case law. The term stop and frisk can mean so many different things to different people, and for many, it has effectively lost its legal meaning. And I'm going to give you what I learned in efforts to research the matter. Back in 1968, the U.S. Supreme Court ruled in Terry versus Ohio that stop and frisk is constitutional so long as a police officer has reasonable suspicion, meaning they have specific and articulable reasons to believe a crime has been, is being, or immediately will be committed by the person, and that person might be armed. For example, imagine that someone just robbed your house and you called the police. And when the police arrive to your home, a neighbor says, I saw someone in a green shirt running down the street in a suspicious manner with a television in their hand. Then it would be constitutional for those officers to stop that person. And you probably want the police to stop them if that means that you get a chance to get your things back. The problem is that for decades, really since its inception, the way stop and frisk has been implemented is, in many cases, unconstitutional. Either police officers have not had reasonable suspicion, or while police officers may have had reasonable suspicion, they are only stopping individuals of a certain race and gender. And again, this is usually Black men. Additionally, many people do not know that on November 4th, 2010, the ACLU of Pennsylvania and the law firm of, and I'm going to chop this up, and Dave Rudowski is on, and he's going to correct it when he speaks of Cares, Rudowski, Messing, and Feinberg, filed a federal class action on behalf of 8 African American and Latino men who were stopped by Philadelphia police officers solely on the basis of their race or ethnicity. The suit, Bailey versus the city of Philadelphia, alleged that thousands of people each year are illegally stopped, frisked, searched, and detained by the Philadelphia Police Department as part of its stop and frisk policy. On June 21st, 2011, the city of Philadelphia and the ACLU announced that they had reached a settlement agreement. As part of the settlement, the Philadelphia Police Department now collects data on all stop and frisk and stores this information in an electronic database. It also provides officers with some training and supervision with respect to stop and frisk practices. Additionally, the agreement establishes a monitoring system in which the police department, the plaintiff's counsel, and an independent court-appointed monitor who reviews and analyzes the data. The settlement agreement, which resulted in what is referred to as the Bailey Consent Decree, means that the city could be sanctioned if they ignore the problem of unconstitutional stop and frisk. Also, it should be noted, and we will hear testimony today, that the consent decree has helped to reduce the number of stops, and we hope when we hear data that it has improved the quality of stops. But, and this is an important but, we still have a long way to go. We are not where we should be. For example, on November the 20th, 2018, the ACLU of Pennsylvania published a press release entitled, "After 7 years, report shows Philadelphia police continue to illegally stop and frisk pedestrians." And just a year and a half ago, on January 11th, 2019, WHYY published an extensively researched article entitled, "In Racially Diverse 14th Police District, Philly Police Target Black Drivers 3 times more than whites, analysis shows." I know Councilwoman Bass and I share the 14th Police District. More recently, on April the 27th, the ACLU put out a press release entitled, Latest reports on stop and frisk in Philadelphia show a need for continued action by city and police leadership. So, like I said, while the consent decree may be moving us in the right direction, we still have a long way to go. Why a ballot question, Sherelle Parker? From the research that my staff has done, no other big city in America has allowed their citizens to formally weigh in on stop and frisk via a ballot question. In my opinion, right now, we have the perfect opportunity to hear the collective voice of our citizens on this important issue. It is my hope that the residents of Philadelphia will feel empowered by this ballot question. It is my hope that the residents of Philadelphia collectively and formally share their opinion, and to be quite frank, I hope they will vote yes, to call on the police department to eliminate the practice of unconstitutional stop and frisk. And it is my hope that our police department and our new commissioner, Danielle Outlaw, that she can use the collective voice of our residents as a mandate to continue her efforts to root out all instances of unconstitutional stop and frisk. I want to now thank a few people who have served not only as my sounding board, but they provided sound legal advice to me when we were working on this question. That's Dave Rudowski, whose firm, along with the ACLU, sued Philadelphia back in 2020. Michael Cord, who has been working on social, economic, and legal justice issues for over 25 years in this community, and speaking out for Black and brown people long before it became a very popular thing to do. And District Attorney Krasner, along with Mike Lee from his office, I want to say thank you all in advance for your assistance. We've invited them all here to testify, and I very much look forward to hearing what they have to say. In conclusion, let me note this for the record. I saw an article in the National Review, of all places, that hit the nail on the head. The article was written by a gentleman named Theodore, or Ted R. Johnson. He's a senior fellow at the Brennan Center for Justice, a retired commander in the U.S. Navy, and an African-American man. The article is titled, "America Begins to See More Clearly Now What Its Black Citizens Always Knew." In this article, the author details his own experience with being stopped by the police and spending the night in jail for a minor infraction, an experience that far too many Black men can relate to. He goes on to analyze the current protest movement. He talks about how this time may be different in bringing about real, lasting change, and how racism remains a national Achilles heel, potentially even undermining the very security of our country. At one point, he concludes by saying this: "The protests in response to the killing of George Floyd are not just expressions of outrage at his death or at the long history of the use of excessive force in Black communities. They are also a people's rejection of the state's violence and infringement on the rights, liberties, and autonomy of its citizens. The rallying cry, Black Lives Matters, is an assertion that, given our nation's history on race, America can realize its potential only if it recognizes the inherent value of a group it once enslaved and accepts the right of that group to hold the state and its agents into account." And with that, I would like to hear from our testifiers. And before we begin with the first panel, I want to hear from Councilman Derek Green.
Thank you, Madam Chair. Thank you for this piece of legislation, which gives citizens in the city of Philadelphia an opportunity to voice their perspective on this issue. You've laid out a lot of information in reference to the history of Terry v. Ohio and Terry stop. And what's key is that we give police officers the discretion to stop criminal activity if they have a reasonable, articulable suspicion that criminal activity is occurring. Too often in this country, that reasonable suspicion is a person being of color or being African American. And I can talk to this personally and I think some people on this call have heard me say this story, that I was one time leaving the district attorney's office as an ADA, and I was pulled over by police. And as I was going, the DA's office was on 14th and Arch, and I was going up the ramp to the parking lot. The police pulled me over, and they said I fit the description. So my question is, what was the criminal activity I was engaging in? Because one, I'm a lawyer. Two, I'm leaving I'm an assistant district attorney, leaving the DA's office. And to stop someone, you have to have a reasonable, articulable suspicion of criminal activity. So what could be that reasonable suspicion of criminal activity other than me as a black man leaving the DA's office, walking up ramp to my car, and I fit the description? So the reason why this piece of legislation is important to give citizens in the city of Philadelphia an opportunity to voice their perspective. We know what should occur and what should not occur, but too often that reasonable, articulable suspicion is being African American. Thank you, Madam Chair.
Thank you, Councilmember Green, and I really wholeheartedly thank you for your willingness to share that very personal experience. The chair recognizes Councilmember David O.
Thank you very much, Chairwoman, and I want to thank you for your resolution and for your work doing this. We have several lawyers in this group, as well as a district attorney and others, criminal defense attorney Michael Cord, and it's very well known. It's shocking, unfortunately, that we have to do this, because it's constitutional law that you cannot go around just stopping people on a hunch, a suspicion, or they fit a profile. And it almost is as though we have no control over our police, because it's been said many times it's unconstitutional, you can't do it, and there are a lot of consequences to this type of action. But I think the reason it continues, and it's something that we're all dealing with right now, once you have convinced a young person who wants to do good that doing good is stopping people, you say, oh, we're going to stop murder, we're just stopping frisk for weapons. After years of that, try and get them to change their mind. And so it's so important that we stop now. It won't stop until we go through this, but it really must stop. Thank you very much.
Thank you, Councilman O, for sharing your legal perspective with us. You, Derek, and the other Councilman O'Neill, you guys bring a very important added information to us, to this hearing, and we appreciate you for that. Chair recognizes Councilwoman Cindy Bass.
Well, good afternoon, Madam Chair, and I want to thank you also for bringing this this bill forward. This is really, really important. As the mother of a 11-year-old girl, but I've also raised an African-American male. I'm not going to say how old he is right now, because I'll put him on blast. But it's really important to have this conversation. A lot has happened in the last couple of weeks. It seems like all of a sudden people are starting to get it, so to speak. And so this conversation is very, very timely. And I really just wanted to thank you for that. I think it's important that we are having this conversation as a body. And I'm glad that other people are a part of the conversation. I also wonder, though, why when so many African-American men said, I'm in pain, something is wrong, this shouldn't be happening, our voices weren't heard. And I get it. We needed the collective to be able to be heard, but there is pain in that as well. And so I thank you for bringing this forward, Madam Chair.
Thank you, Councilwoman Bass. And again, you Councilwoman, I know you remember when that article came out regarding the 14th Police District, and all eyes were on both of us as we both shared that district.
Absolutely.
Thank you. Rachel, will you please call the first panel we had to testify this afternoon on bills?
Madam Chair?
Yes.
Before you do that, since this committee is almost like group therapy, I'm going to share. And so growing up in West Philly as a young man, Not the best of them, but not the worst of them that were out there. I had a summer job, Madam Chair. During that summer job, I saved my coins, and I bought what a lot of young men know as a hoopty. Hoopty is a car that barely rides. And, you know, it's on a wing and a prayer and a lot of duct tape.
You were cool. You were cool in it, Jones. I'm sure you were the coolest hoopty driving person I know.
So, I was picking up a young lady on a date. First time ever driving a car. So back then, you had these paper license plates. They were temporary plates, if you remember those. And so I had to go from my end of West Philly to a nicer end of West Philly where, you know, the houses were semi-detached, you know, big lawns and good stuff like that. So my hoopty stood out. I guess I stood out. I managed to pick her up, and not more than a block or two from her house, we were pulled over. When we were pulled over, I was taught at the time to be very polite. You know, my father gave me the talk that I hope you never, ever have to give your son, you know, how to be extra polite, no sudden moves, look them in the eye, blah, blah. The more I said, yes, sir, the madder that police officer got, because I don't know why. And so by the end of him running those paper tags through, him looking at my license, him asking me why I was up there, him, not believing half of it, not double checking everything I said, maybe 40 minutes into it, he gave me back my paperwork. And he said, the next time you say, yes, sir, I'm gonna throw you in this wagon. So much so that the young lady beside me had to put her hand on my leg just to calm me down. Needless to say, we didn't go on that date that night. Needless to say, we pulled back around, not out of fear, but out of anger, like it ruined my day. Now, this is a guilty confession. When I first got elected, I couldn't wait to get pulled over. Could not wait to get pulled over because that would have been some vindication of that experience. Nobody should have that kind of feeling as a young man or a grown man. And they're like, we should have the same experience that other kids in other parts of Pennsylvania had. When they see the police, they see their protector and helper. They see their friend and people they grew up with and care deeply about them. I want that for me, and I want that for mine, and we as taxpayers deserve it. So thank you for moving this issue, this uncomfortable conversation forward, Madam Chair. Thank you.
Thank you, Councilmember Jones, for sharing that very personal experience. The testimony, your personal testimony, is what will affirm for other people that they're not alone when people think they're crazy. With that being said, Rachel, please call the first panel we have to testify this afternoon on bill numbers 200076 and resolution number 200080.
Vanessa Garrett Harley, who is joined by Craig Straw and Marcel Pratt, and Hans Manos.
Good afternoon.
Hello. Good afternoon. We wanted to make sure that you are all connected and ready to proceed.
Yes,
Just a sound check from each of you. Okay, please state your name for the record and proceed with your testimony. Vanessa?
My name is Vanessa Garrett Harley. Good afternoon, Chairperson Parker and members of the Committee on Law and Government. I'm sorry, little technical difficulties. Okay, can you see me now?
Yes, ma'am, we can.
Good afternoon, Chairperson Parker and members of the Committee on Law and Government. I am Vanessa Garrett Harley, Deputy Managing Director for Criminal Justice and Public Safety for the City of Philadelphia. Joining me today are Marcel Pratt, the City Solicitor, and Craig Straw, First Deputy City Solicitor. I'm here to testify in support of Bill number 200076 and Resolution number 200080, introduced by Chairperson Parker, which calls on the Philadelphia Police Department to eliminate the practice of unconstitutional stop and frisk by providing a proposed amendment to the Home Rule Charter. If this measure is approved by City Council, a ballot question will be presented for the city's voters in the November 2020 election. Thank you for the opportunity to speak with you this afternoon. By way of brief background, pedestrian investigations, often referred to as stop and frisk, allow police officers to stop any person without making an arrest and potentially frisk them based on a reasonable suspicion that the person has committed or is about to commit a crime. That rule of law, as you've heard Chairperson say, stemmed from the U.S. Supreme Court decision, Terry versus Ohio in 1968. In 2019, Philadelphia police officers conducted fewer pedestrian stops and frisks of individuals in the city of Philadelphia than during any prior year. Even more importantly, the percentage of stops lacking in reasonable suspicion or unconstitutional stops, already down well over 60% since 2015, was lower in 2019 than in any other year to date. These dramatic changes are the result of the police department's extensive proactive efforts and measures to educate, re-educate, and retrain police officers on the applicable constitutional standards for conducting pedestrian stops and properly documenting those stops on the 7548A form. But despite these improvements, the Philadelphia Police Department strives to do even more, and in the past year has devoted more resources to the issue than ever before. Since 2016, the Philadelphia Police Department has implemented proactive measures to reduce all unconstitutional stop and frisk in the city of Philadelphia. To date, the police department has made significant progress. In 2015, there were 213,870 total stops, and approximately 110 of those were deemed to lack the reasonable suspicion necessary to meet constitutional standards. By contrast, in 2019, police officers conducted 76,937 stops, while approximately 9,200 of them were deemed to lack the reasonable suspicion necessary to meet constitutional standards. This reduction represents a 92% decrease in pedestrian stops lacking the reasonable suspicion necessary to meet constitutional standards from 2015, approximately 110,000, to 2019, down to approximately 9,200, and a 64% decrease in the total number of pedestrian stops from 2015, 213,870, to 2019, 76,937, which represents the time period since Mayor Kinney took office in January 2016. While the city and the police department are certainly not satisfied with these numbers, and we certainly recognize that additional work is definitely necessary, the numbers reflect significant progress in reducing and eliminating unconstitutional stop and frisk in the city of Philadelphia. Starting with the fourth quarter of 2019, the police department began implementing a new progressive discipline system, which entails a much wider review of the 7548A forms. Police reassigned and trained several police officers and supervisors from other roles so that they could focus on this project exclusively. A description of the system is as follows. In order to implement the progressive discipline process, the police department audits and inspection unit not only conducts its own review of randomly selected forms and implements discipline on that basis, but they also review a significant number of forms submitted by counsel for the plaintiffs in the Bailey litigation, which is the 2020 federal class action lawsuit that council chairperson referred to, involving claims of unconstitutional stop and frisk. Any non-compliant officer and or supervisors will be subject to progressive discipline for forms submitted and approved without the necessary showing of reasonable suspicion. Cities are at the forefront of change and should be the driving force of reform. We will continue to make the fair treatment of all Philadelphia residents and visitors a priority by enhancing our progress and eliminating all stops which do not meet the threshold of reasonable suspicion and thus may be deemed unconstitutional. That is definitely our goal. This concludes my testimony. I, along with Craig Straw and Marcel Pratt, will be happy to respond to any questions you may have at this time. Thank you.
Thank you, Vanessa, for your testimony. And since you just mentioned Marcel Pratt, I also have to say a special thank you to you, Marcel, and your entire team, because obviously when we were working on getting this drafted, we would not have had anything to send to Rudowski and Cord and Krasner. Had your team over in the law department not assisted us. I want to say thank you on the record for that. Hans, if you can proceed with your testimony and just state your name for the record.
Oh, absolutely. Hello, my name is Hans Manos. I'm the Executive Director of the Philadelphia Police Advisory Commission. And I'm here, and I want to thank you for the opportunity to testify in support of Bill number 200076, which of course calls for the Philadelphia Police Department to eliminate the practice of unconstitutional stop and frisk. Councilwoman Parker, I want to thank you very much for introducing this in such a deeply personal way. And I want to thank you for affirmatively mentioning George Floyd's name and for mentioning the fact that this is about racism and about anti-Black racism in particular. I think it takes a great deal of courage to do all of those things and to keep us all focused on what is at stake here. So I appreciate that. And I appreciate the other council folks for also sharing their personal stories. So I think that the residents of the city are inspired when we're able to speak so personally about the issues that are before us. As you are aware, the Philadelphia Police Department, by policy, forbids the use of unconstitutional car or pedestrian investigations, searches, and frisks. Despite this, as it's been mentioned, the ACLU and Plaintiffs' Counsel has found that nearly 40% of the stops were not legally justified in their last audit. Further, they highlight that the stops of Black Philadelphians are disproportionate and not legally justified stops of Black Philadelphians are even more disproportionate. I'd like to begin this testimony, and you have my long-form testimony, which I encourage you to review, by highlighting some of the case studies that we received here at the PAC, some complaints that we had, including one yesterday that I just learned of this morning. And that one is a man who was stopped by police because he had pulled into a gas station that was closed and he was not aware of it. The police officers exited their vehicle and pointed their guns at him and his passenger. Both of them were incredibly frightened, and the officers explained to them that they thought it was suspicious that they were at a closed gas station and approached them as a result. Did not explain why they were stopping them, and did not explain why they needed to remove their firearms and point it at them. That stop, we will see how it is investigated, and I'm happy to update you all on the status of that. But I have some other cases where a man, for instance, was believed he was racially profiled and stopped by the police. He complained, and the investigation was undergone, and the officers received training and counseling for this for their stop, but because they did not document the stop. That was the training and counseling issue there. Another case, a man was investigated and pulled over and stopped because he supposedly had an inoperable taillight. The investigation showed that the taillights of the vehicle were both operating. There was no issue there. But despite this pretextual stop, the officers were found not guilty at the PBI, at the Police Board of Inquiry. Another one, a man reports he was stopped for about 2 hours. And during that time, his items were searched, his ID was taken, and he was referred to as the one. The investigation revealed that the officers were searching for somebody, but they failed to document that they frisked him, and they were referred for training and counseling. In another case, and I promise this will be my last one, a man was stopped by the police, and they began to question him about whether or not he was drinking, and were accusing him of drinking. He luckily happened to have his deaf and hard of hearing card on him and presented it to the police department, so they could recognize that he was deaf, not intoxicated. These officers, after an investigation, were sustained for, again, not documenting the stop. And so I think you know where I'm going here, but I think that there's some issues that are related to this, certainly the stops that we don't know about. But I think also, as Councilman Jones very, very personally highlighted, that the quality of the stops is a secondary conversation that I think we will need to have. Are officers engaging in pretextual stops? That's very possible, but that would not make it illegal. Does that change the way that folks feel when they are engaging with police officers? And are we doing enough as a city and as a police department to ensure that the quality of the stops, the professionalism, the language that is utilized, does not alienate folks and does not create a negative relationship between the police and the community? So what I'm saying here is that even though the resolution calls for the police department to eliminate the unconstitutional practice, there also needs to be an accompanying directive and disciplinary code that mandates what discipline officers will receive and some guidance about how they interact with residents. So I'll make some other recommendations here. And again, these are in my long form, which I encourage you to review. I'm happy to answer any questions about them. I'm happy to talk about them. But I will say that the audit program that I'm aware of, and I could be incorrect here, does not mandate any reference for discipline. And if I'm incorrect about that, I'm happy to circle back. My understanding of the audit program that exists is that it is a separate and distinct process from a disciplinary process. So if I am correct, and again, we'll double check this, that means that in order for an officer to receive discipline, there must be an accompanying complaint. You must complain about what occurs. To me, that is an issue. A secondary recommendation, and this is in my long form, there's a sample of this the NYPD in Chicago uses, is a stop receipt program. When someone is stopped by entities in those jurisdictions, they're given a receipt. It's very easy to fill out. The officer says their name. We'll check one of the pre-written reasons why they were stopped, and if that's not available, there's another reason that they can write in. There's other they can write it in. That'll help folks understand who they encountered, because some of our residents, if they are stopped, are too nervous, maybe a gun was pointed at them, or maybe they're nervous because they're nervous around police, to take note of what had occurred, and this would help facilitate contacting officers. We would also remind them that they need to fill out the paperwork that is required of them. A body-worn camera audit program. This, to me, can be helpful in two distinct ways. One of these is to find stops and assess those that have not been documented, but also, again, to run back to my conversation on the quality of stops, to identify those that are called lawful but awful. And that's what it sounds like. Those that may not be illegal, but that the quality of, maybe there's some curse words, maybe there's some stuff that could be trained away or pointed out. Right? And so I think identifying lawful but awful is an important next step, or next hurdle to improving the relationship between the police and the community. Because again, I can't say it enough, the quality of the stops is often called into question, if not the legality of them. To build on this point, I would embed effective communication into training. I think stops are problematic, again, because of the quality, and we could utilize reality-based training to assess how officers interact with folks, and also utilize the existing body-worn camera footage to highlight exceptional officers, and there are many of them, and some other problematic officers, and really show that to our recruits and to our current officers about what we expect and how they can improve. I think that the mayor, I applaud the efforts from my next recommendation. I applaud the efforts of reconciliation in the city. I think the police department should lead on this and should be involved in this, because the reconciliation and the acknowledgement of past harms is incredibly important. For those of you who are religious on this meeting, it's also very biblical. You know, the idea that you atone for what you've done wrong as an entity, that is possible. And I think the acknowledgement of that starts with the overuse of stop and frisk, and admitting that was had a deleterious effect on the relationship for the community, and owning that mistake, that they led on that. The police department, in my opinion, I've noted this before, is reluctant to admit that they they own the lion's share of the responsibility for the relationship between them and the community having broken down. And then I'll say, we can proactively measure racism. I think that what Plaintiffs' Counsel has effectively done here is highlight systemic racism. They've measured it. And we continue to do that in other areas of the police department. And there are scores of examples of other jurisdictions that take things like language use that's disproportionate towards people of color, and those who are, and other members of the city, and literally drilled down to the procedural justice of that different folks are experiencing. And we can do that here in Philadelphia. We're capable. Finally, in terms of recommendations, independent investigation. I want to thank the City Council for your support of the Police Advisory Commission as an entity over the last few weeks. Many of you have reached out to me personally. Many of you have come to our town hall and have otherwise indicated your support of us, and we appreciate it, and we want to make you proud. The independent investigations that exist in other cities are led by their oversight committee, and I think that Philadelphia is on the precipice of that now. I look forward to working with you all to move that forward, but I think now more than ever we're understanding the importance to the residents of an independent investigation into these types of issues and an independent response. I'll say this, Councilman. Yes.
Because we have 3 bills, I'm going, and I appreciate you sending your written testimony. We've got to wrap up. Yeah.
Okay, no problem. I'll finish right now just to say this, that I understand that there's been more murders than days this year, and that the police department has to do something. All I suggest is to do that responsibly within the law. Thank you very much.
And Hans, thank you. And listen, I'm going to ask you, Vanessa, in the first panel, to please stay on, because we have to get the testimony of our next panel in. I have Councilwoman Maria Quinones Sanchez and Councilwoman Kim in queue, but we're not going to call on members until we hear testimony from our next panel. So Rachel, can you please call up the next panel? Once we hear their testimony, then we will just take all questions.
The next panel is David Rudovsky, Larry Krasner, and Michael Cord.
Thank you all for being here. Please state your name for the record and proceed with your testimony. Mr. Rudovsky.
Good afternoon, everybody. David Rudovsky. I'm glad to be here. I support the measure that is before City Council. As has been mentioned, I am one of the lawyers that brought the Bailey versus City of Philadelphia lawsuit that was brought in 2010 to address 2 very serious problems with respect to stop and frisk, and they've been touched upon. First, at that point, there were 260,000 stops in the City of Philadelphia. At that time, almost 50% of them, by our reading of them and the police department's reading of them, were without reasonable suspicion. 50%, that meant 130,000 people had been stopped illegally. And with respect to frisks, which is a separate part of stop and frisk, almost 60% of the frisks were without reasonable suspicion. The city agreed to establish that database, and at the same time, not only did we find what we call Fourth Amendment violations, stops without reasonable suspicion, frisks without reasonable suspicion, but enormous racial disparities. In a city back in 2010, which was about 50% white and about 50% minority, close to 85 to 90% of all stop and frisks were of minorities. 80% of blacks, 10% of Latinos. And when we did the analysis, the regression analysis, and took into account crime rates, economic conditions in certain communities, age, police deployment, none of that explained the racial disparities. They remained after that. To the city's credit, they agreed to a consent decree. They agreed to retraining of the police. But here we are 10 years later, and I will also give credit to Mayor Kenny, because in the first 4 or 5 years, we saw very little progress in reforming stop and frisk. Mayor Kenny and Commissioner Ross have done a better job, but it's another situation of the glass maybe half full, but it's really half empty. And I can tell you from our most recent report to the court, we looked at stops and frisks in 2019, and let me just give you some data which will show where there's been some improvement, but where we still have serious problems and why this legislation is needed. So in 2019, we did a complete analysis of stops and frisks in the city of Philadelphia. As you've been told, there were about 77,000 stops. The one area in which we've seen improvement, about 84% of those stops were with reasonable suspicion. That's a large improvement. Still means 16% were not. That's thousands of people who continue to be stopped without reasonable suspicion. More troubling, as you know, a frisk can follow a stop. It's not just a stop. A person can be frisked, which is even more invasive of their privacy. And what we found was that only 62% of the frisks were being done with reasonable suspicion. That is close to 40% of the frisks, by what the officer wrote down, was without reasonable suspicion. Even more startling is how ineffective this program has been in its main purpose, taking guns off the street. Of all the stops that were made in 2019, it was less than 1% of those stops that produced any contraband, and less than 0.5% that produced a weapon. So in other words, 99% of those stops produced no contraband. And it is fair to say that some stops you make, you don't expect to find contraband. So let's look at the data with respect to frisks. Because when an officer frisks, an officer is saying, under the law, I have reasonable suspicion this person is armed and dangerous. They can only frisk in that kind of situation. We looked at a sample of frisks. We looked at it, the police department looked at it. 485 frisks in one of the quarters, 7 firearms. Again, 99% of those frisks did not find what the officer said I had reasonable suspicion to find. That certainly calls into question both the standards they're looking at and perhaps the truthfulness of their allegations. Let me give you just 2 examples. We often see officers say, I frisked this person because I saw a bulge, right, in his back pocket, around his waistband. We looked at 88 cases in which an officer said, I saw a bulge and therefore I believed he had a weapon. One firearm out of 88 bulges. Where police stop somebody and frisk them because they said it was a report of a violent crime or a weapon, this is hard to believe. We looked at 164 frisks that were conducted in that situation. One firearm out of 164 where the police were testing to a complaint about a violent crime or a weapon. Maybe even more disturbing is the large number of stops that are for quality of life. I think the people in the city of Philadelphia think, well, people are stopped because, it's a serious crime that's being investigated. A robbery, a murder, an assault, a theft, something like that. It turns out that over 40% and close to 45% of all stops, almost half of all stops being made by the police this year and last year, are what I call quality of life. Somebody with an open liquor container, littering, truancy, small amounts of marijuana. Now, we want to take care of that problem, but there's no reason for stopping and frisking some of those people. An officer, somebody with an open liquor container, why doesn't he just say, hey, buddy, put it away, right? The same thing for littering or whatever it might be. But what's going on here is that enormous numbers of people are being stopped. My suspicion is they're only being stopped in that situation so the officer can check to see if there's an outstanding warrant. It often never happens. But if we're concerned about the number of stops, and we should be, there's an easy answer. Stop making stops for quality of life incidents. There are other ways of handling that. In fact, people in the community ought to be dealing with that. But the police are, you invite problems, right? You have antagonism, and we wonder why people in the community, therefore, are not helpful with the police. So that's the Fourth Amendment picture. We still have a long way to go. We still have a significant number of stops and frisks without reasonable suspicion. We're making stops in a lot of cases that don't make sense. And we have an incredibly low hit rate, incredibly low hit rate of what we're trying to do with respect to getting weapons off the street. Equally troubling is the lack of progress, and here we've seen no progress at all, despite the reduction in the number of stops, on racial disparities. The city now, by the most recent census figures, is about 35% white, it's about 42% African American, and about 14% Latino. And about 7% Asian, so 35% white, 65% minorities, right? In 2019, in the data we looked at from the police department, the stops were 78% of minorities. Remember, minorities are only 65%. They were 78% of the person stopped. Frisked, it was even higher. It was 89% of everybody who was frisked were minorities, including 80% African Americans. But beyond that, when we dug a little bit deeper, the statistics became even more troubling. When we looked at stops and frisks that were made without reasonable suspicion, right? Those situations where everybody agrees they shouldn't have been made in the first place, the rates of stops of blacks was significantly higher than whites and Latinos. That is, so for example, with stops on race and reasonable suspicion, where there was no reasonable suspicion, with respect to blacks, that was 18% of the stops of blacks, but only 11% of whites. Same data as to frisks, close to 40% of the frisks of blacks were without reasonable suspicion, and only about 25% of the frisks of whites were without reasonable suspicion. What does that mean? It means police are stopping minorities far more often with no evidence. That is, there's a higher threshold before you stop a white person than when you stop a black person in the city of Philadelphia. A lot of people say, and it's correct, just because you have the racial disparities, in Philadelphia, for example, 65% minority and close to 80, 85, 90% of the stops, that doesn't prove racial discrimination. Our statistical expert for the past 10 years has been analyzing that data. As I said before, through regression analysis, plugging in factors of crime rates, of police deployment, of economic conditions in certain areas of the city, so on and so forth. And for 10 years has reported those factors don't explain the racial disparities. And if we go further, we know that's not true. And this, I'll wind up with this data as well, because I think all this data informs the kind of discussion that we're having and where we have to go. When we look at the frisk rate in Philadelphia, it turns out, and this repeats some of the data I said before, blacks are 40% more likely to be frisked without reasonable suspicion. And with respect to stops, blacks are 50% more likely to be stopped without reasonable suspicion. And again, this isn't our data. This is the city's data. This is the data that's given to us. It's quite remarkable. Our audits and the city audits have been fairly consistent. We're both finding these patterns. The city has tried to explain these racial disparities and saying there's more crime in black communities, there's more serious crime in black communities, and that's why we have more stops. That could be an explanation, but as I said, all the statistical work that we have done doesn't demonstrate that. So I say two things. One, I give credit to the police department and to Mayor Kenny for some of the improvements. I'm hopeful this new disciplinary system will bring down the problems that we have and improve the system. Some stop and frisks are necessary and they're important. We continue to stop too many people. We continue to frisk too many people. We continue to do that without reasonable suspicion. And we continue to see the kind of racial disparities that fuel the despair that we're starting to see in this country. Fortunately, I think we're starting to get a response to that. Philadelphia has been somewhat of the forefront in dealing with these issues. We should continue, but we can't let up at this point and just say, well, we've made all these improvements. We don't have a problem anymore.
Thank you, Mr. Rudowski. District Attorney Krasner. And listen, we're going to ask all of you to stay because my colleagues have a whole lot of questions, and we need to ask you some questions based on policies that are in front of council now that are being considered. So we need to get everything that you have to say on the record. So thank you, District Attorney Krasner. Please proceed with your testimony.
Thank you, Chairperson Sherelle Parker and the Committee on Law and Government for allowing the DAO to testify during today's public hearing about bill number 2 lots of zeros 76 and corresponding resolution number 2 lots of zeros 80. I'll just call them 76 and 80. The DAO is a committed partner in public safety as we seek fair and equal justice in Philadelphia and in the Commonwealth. I have prepared remarks that frankly have mostly been covered. So I'd like to switch to some of my thoughts on this, the ways that I believe I can contribute. First of all, I think it is really important to realize that consideration of this resolution is an opportunity to hear, as Chairperson Parker said, the collective voice of citizens at a crucial time in this country's history. It is a crucial time when people who might not otherwise be inclined to vote are being told, you matter, your lives matter, and you can, in Chairperson Parker's words, weigh in. It is an opportunity, as Chairperson Parker said, to shine a glaring light on modern police tactics. And all of that means an increase in voter turnout. It means greater participation by people who feel empowered at this time that they can make a difference and they can do things, whether it's marching in the street or it is marching to a polling place, which we all fervently hope that they will do. The problem with illegal stop and frisk, the problem with walking while black, driving while black, the problem is it breaks trust. And breaking trust between communities and the officers who serve them results in reductions of safety. What do I mean by that? Well, first of all, the experience of many young men, especially African-American men, is an experience of repeated humiliation over nothing, over having been at a bus stop or come out of a fast food place and having sometimes the same officer stop them repeatedly. What does that do to a young person who's full of all kinds of, issues that relate to being a teenager, figuring out your future concerns? What does it do when you're humiliated time and time again, especially as a young man? What are the results? Does that make you want to be a police officer? Because we could really use some young folks who are coming from communities that are marginalized. We could really use them as police officers. But if you humiliate them often enough, they're not going to do it. What does it mean in terms of the ability to get witnesses? Well, let me tell you straight up, it is very difficult for us to get witnesses to come forward on the most violent and most serious cases we have, including shootings. It's very difficult for us to get people to come forward and say, look, something terrible is about to happen. Go intervene. That is in many ways due to the trust that has been broken and broken for decades. Rudy Giuliani did not have it right then or now. He had it completely wrong. When you break trust between people and the officers who serve them, we are less safe. We are not safer. But let me talk about something else, another form of safety that we are losing, because it's a real issue. Look at what happened to George Floyd. Look at what happened to Eric Garner. And think about this for a moment. When you have an illegal police encounter over something minor, it often becomes overheated. And it becomes overheated in part because of the injustice that is being served on the person stopped, the person searched, the person arrested. Let's remember what George Floyd supposedly did. He goes into a store with a $20 bill that turns out to be counterfeit. It is extremely likely he had no idea it was counterfeit because he came back outside and sat in a car with the door open for a long period of time. Store employees came out and told him something to the effect of your bill is counterfeit. He talked to them. They walked away. He stayed right there in that car. There is every indication he had no knowledge that that $20 bill was counterfeit. And yet over a $20 bill, he ends up dead in a superheated encounter with police. How is that any different than Eric Garner? Eric Garner is selling Lucy cigarettes. That's what he's doing, and he ends up dead. It is a very, very serious problem when you take a minor encounter that did not have to be, that is rooted in injustice, and you create the potential for a disaster. So every one of these stops where the turn signal was working and the police said it didn't, every one of these stops where they say you fit the description and there was no description, every one of these becomes a potentially dangerous situation for police officers who frequently are forced to do this tactic, don't want to do this tactic, and it becomes a very dangerous situation for what are often young people, but regardless, they are people, and that's what matters. So I kid you not when I say this nonsense needs to end. It makes us less safe. We are supposed to be about public safety. We are supposed to be about justice. This tactic has been a disaster. It is part of my hope that as council considers budget and various agencies, that there is support for the Police Advisory Commission, that there is support for Mr. Manus and his organization, that there is support for the Public Defender's Office, who need to be fully funded if we are to address the issues that are becoming the civil rights issues of our time. And we can see them in the streets. It also means, of course, funding the District Attorney's Office so our Special Investigations Unit can hold police accountable. I hope I'm not bragging when I say in the entire Commonwealth of Pennsylvania, the one jurisdiction where it is clear that the DA's office is trying to even-handedly and appropriately hold police accountable is Philadelphia. And our SIU unit, Special Investigations, is doing a remarkable job. It is not beyond us to be able to do more with civil rights enforcement because, as Mr. Rudofsky indicated, what is written on these papers does show more justification for the stops. That can mean one of two things, though. It can mean that there really is more justification for these stops, as we see walking while black turning to driving while black, which is what's really happening. Or it can mean they're learning to tell better stories. And the only way to really get behind that, to get behind the words on the page, to find out the truth, to reward the officers who are doing the best, and to call out the officers who are doing things that are actually illegal, like filling out police paperwork that is untrue. The only way to get that is to do more investigation, which is within the ability of a properly supported DA's office to do. Thank you very much, Chairperson Parkman.
Thank you again. Please don't leave. Our colleagues are going to use a whole lot of what you say as we're deliberating on issues that are in front of council. Now we'll hear from Attorney Michael Cord. Thank you so much for joining us. Please state your name for the record and proceed with your testimony.
My name is Michael Cord, and I want to start by thanking Mr. Rudofsky and Mr. Krasner for breaking it down as well as they did. I certainly want to thank the impressive panelists that spoke before those two gentlemen. I definitely, no doubt about it, want to thank the council persons who are part of this, and especially you, Councilperson Sherelle Parker, for pulling all this together. What I decided to do in terms of my brief presentation, maybe 5 to 7 minutes. Normally, I don't speak from notes, but when I deal with issues like this, I need notes or teleprompter, because if I don't, I'll say something that I'll regret. I'll go off, I'll yell, I'll scream, and I'm serious about that. You know, I'm known as the self-described angriest black man, and I wear that moniker on my sleeve. James Baldwin said to be black and conscious in America is to be in a constant state of rage. It's not a destructive rage, but it's still enraged. Let me just slightly go off the script for about 30 seconds before I go to my point, and I rehearse what I'm about to say so that I don't go too crazy. I'm a lawyer today because of retarded Roger. And I use that phrase, retarded Roger, because as a kid who didn't know about improper terms, there was a man who had to be 35, 40 years old, but had the mental capacity of maybe a 5 or 6 year old. So we as kids would see, as we would now call him Mr. Roger, we would tease Mr. Roger by calling him retarded Roger. He was mentally disabled. It's a long story, but I'm not going to go into detail. Bottom line is, I'm born and raised in North Philly at 20th and York. And 1 block up and 1 block across is 19th and Cumberland. and quote unquote retarded Roger was given a job by a store owner who felt sorry for this man because of his mental incapacity and gave him a job, completely harmless. Long story short, for whatever reason, police are driving north on, and this had to be in the mid-70s. The police are driving up 19th Street. They see somebody in the store after hours, not realizing that Mr. Rogers is working there, moving boxes around. The cops is coming blazing, fire 12 to 13 shots, killing retarded Roger instantly. No news reports, no media coverage, nothing. Just a poor black guy from the hood shot and killed. That's my experience with police. Police, for me, were never officer friendly. They were always an occupying army in the neighborhood. So when I see people like you all, the council people, and learned scholars like Mr. Radowski trying to fight this fight, I applaud you. Having said that, let me jump into this. As a criminal defense trial and appellate attorney for more than 25 years, and a public policy and the black community adjunct professor at Temple, I enthusiastically support the ballot question proposed by the Honorable Councilwoman Sherelle Parker that necessarily seeks to end unconstitutional stop and frisk in Philadelphia. And I'm going to cut through some of the stuff. In particular, I wholeheartedly support it because it seeks to amend the Home Rule Charter to, quote, call on the police department to eliminate the practice of unconstitutional stop and frisk consistent with judicial precedent, unquote, thereby prohibiting police officers from stopping, quote, someone unlawfully because of his or her race or protected characteristics. There's no way that anybody could reasonably oppose this ballot question, because the question is, should we stop doing unconstitutional stuff, pardon my language. So the question is, should we stop doing unconstitutional stuff? The answer is obvious. We should, and that's what this ballot question proposes. I love the fact that it uses the word unconstitutional in the ballot question and unlawful. So again, we're asking the public, should we stop doing unconstitutional stuff and should we stop doing unlawful stuff? I also love the fact that the language of the proposed ballot question talks about judicial precedent. And I'm not going to bore anybody like some law school professor, but I love the fact that that was included because there is incredible amount of judicial precedent supporting what we're trying to do here, or what City Council is trying to do here to stop unconstitutional stop and frisk. There's the case Commonwealth versus Hicks, a Pennsylvania Supreme Court decision from 2018. And it starts out by saying the following. I'm going to read just a bit of it. Again, this is the Supreme Court of Pennsylvania, Commonwealth versus Hicks. It was argued in 2018, decided May 31 of 2019. And here's the relevant portion. The Supreme Court of the United States has approved of stop and frisk practices as a limited departure from the requirement of probable cause. Stop and frisk deals with maintaining a balance between a constitutionally protected privacy interest of the individual and the needs and safety of law enforcement. But this, to me, is really key. It makes it clear, remember, we're not just talking about Terry from 1968, we're talking about Hicks from Pennsylvania here in 2019. First, the investigatory stop must be lawful. That's key. The underlying stop must be lawful. And second, to proceed from a stop to a frisk, the police officer must reasonably suspect that the person stopped is armed and dangerous. Armed and dangerous. Not just armed, because the Hicks case involved a man in Allentown who had a gun. And he was at a gas station and he saw a friend and he shows the friend his gun. And I guess somebody in the store must have called the police. The police arrived, but you can lawfully carry a gun if you have a license. That's why the police can't just say that we thought, well, in Philadelphia they can, because it's a different thing. In Philadelphia, we have rules. We have 6106 and 6108 of the Crimes Code. But to make a long story short, the case involving Hicks involved a man who in fact had a gun, but a gun is not enough. Then it goes on to the Robinson case, and this is important before I get back to my prepared statement. The Hicks decision by the Pennsylvania Supreme Court in 2019 references Commonwealth versus Robinson, a Superior Court decision from 1991, which makes it clear that possession of a concealed weapon in public is sufficient to create a reasonable suspicion that the individual may be dangerous. That's what Robinson says. Once again, possession of a concealed firearm in public is sufficient to create a reasonable suspicion that the individual may be dangerous. That's Robinson by the Superior Court in 1991. Robinson was overruled by the Pennsylvania Supreme Court in 2019. So you can't just say in most counties that the person had a gun. They have to be armed and believed to be dangerous. Let me continue here. I go beyond simply talking about the law to talk about history. And in my prepared statement, I point out that municipal police departments, as they are now known, began as slave patrols. The first one started in 1704 in the colony of Carolina and then spread throughout the South until 1865. What these slave codes did was deputize civilian white men to engage in, quote, the monitoring of rigid pass requirements for blacks, breaking up large gatherings of blacks, searching slave quarters randomly, and inflicting impromptu punishments. That's what the slave code required in the colony of Carolina in 1704 to deputize white men to do to black people. That's 1704. That could be 2020. The very same thing. Deputize civilian white men to engage in the monitoring of rigid pass requirements for blacks, breaking up large gatherings of blacks, searching slave quarters randomly, and inflicting impromptu punishment. 1704, it was true in the colony of Carolina. It's still true today in 2020. I'll wrap this up in 2 minutes. I go on to point out that when we talk about the slave patrols and what happened in 1704 in the colony of Carolina, I don't want anybody to get it twisted and think it's just a matter of something that happened in the South. It happened in the North. In fact, slavery existed here in Pennsylvania beginning in 1684. And right here in Philadelphia, even before 1790. And why do I mention 1790? Because that's when we know George Washington, the father of this country, in America's first White House at 6th and Market, held 9 black men, women, and children in bondage as enslaved human beings. And it was that same location in 1793 that he signed the notorious Fugitive Slave Act. Let me go from 1704 to what happened in 1790 to more modern relevant information. People will be surprised to know that Philadelphia was the first city to be prosecuted by the federal government for police brutality. I'm not talking about a city in Alabama, in Georgia, in Mississippi. Philadelphia, Pennsylvania, in 1979 became the first city in the country to be prosecuted by the federal government. And let me just, I was going to go into the statistics, but Radowski handled that perfectly, so it's no need for me to go into anything more beyond saying black men are being targeted by the police department. And even though they're being targeted less, it reminds me of what my mentor, Malcolm X, said. He said, if you stab me in the back 9 inches, and then you pull it out to 8 or to 7, I'm not going to thank you for pulling it out. You should have never stabbed me to begin with. So the fact that things are getting better with the police department is still not great. Because let's put it on the shoe on the other foot. What if white men were being treated like black men? Would anybody say that that's an improvement? Of course not. White men justifiably will be going ballistic. Something I just want to touch on very quickly because it's not within the jurisdiction of council, it's a state law. It's Legislative Act 111. And Legislative Act 111 of 1968, let me just read this. Legislative Act 111 of 1968 allows a civilian arbiter from the American Arbitration Association to, quote, ignore findings of fact, unquote, regarding brutality and other misconduct deemed founded by the Internal Affairs Division and the Police Board of Inquiry. That act also allows the arbiter to, quote, reject the punishment, unquote, assessed by Internal Affairs or the Board of Inquiry. And this is the key part, and this is in the legislation, quote, even if the facts as charged have been proven, unquote. So to the extent that I'm talking to city council and not the state legislature, I go on to say this. Much of the brutality and other misconduct stems from unconstitutional stops and frisks. And tragically, as recent news reports have proven, many of those unconstitutional stops and frisks lead to the unjustifiable killing of innocent Black people who should have never been stopped in the first place. So if we here in Philadelphia, through city council, can stop the stop and frisk, then we potentially and probably and almost certainly protect Black men from being killed, because you can't be killed until you're stopped. So if we can stop the stops, we save some lives. And finally, I say here, for all the aforementioned reasons, I enthusiastically support the ballot question proposed by the Honorable Councilwoman Sherelle Parker that necessarily seeks to end unconstitutional and unlawful stop and frisk. And I included in my prepared statement some facts about real, legitimate stop and frisk. And without boring you with the details, let me just point out 5 facts that existed in that 1968 Terry versus Ohio case that exist in none of the stops here in Philadelphia. One, it was a veteran detective that has 39 years of police experience and had routinely patrolled that neighborhood. So he knew the people in the neighborhood. He knew the neighborhood, number one. Number two, he actually watched John Terry and 2 other men for nearly 12 minutes from about 300 feet away. Number 3, he saw Terry and a second man talk on the street corner, then separately walk back and forth in front of a jewelry store, look inside, and then come back. 11 times these 2 guys did that, and the cop is just checking them out. Number 4, a third man then joined in the conversation with Terry and the other 2, and he walks back and forth to the jewelry store. Now they're all together. The 5th and final point, I'm already sitting down, but I will shut up after this. After the 3 men together, shortly thereafter arrived outside that store. After all the other stuff, the detective confronted them, asked their names, and when they mumbled their response, the detective spun Terry around, patted his outer clothing, and felt and removed the gun from inside his overcoat. Immediately thereafter, he put all 3 against the wall, patted the other 2 down, and found another gun in a second man's coat pocket. So when we talk about Terry versus Ohio, if every cop could do exactly what this veteran detective did, then we wouldn't have the problems that we have. And I know I said finally 4 times in the last 10 minutes, but I mean finally this time. By the way, it should be noted that the Supreme Court, despite its ruling that approved the search, pointed out that a stop and frisk is not, quote, a petty indignity, unquote, but a, quote, serious intrusion upon the sanctity of the person, and it is not to be undertaken lightly, unquote. The court also referenced and warned against, quote, the wholesale harassment of which Negroes frequently complain, unquote. But Philadelphia police, and this is my language, but Philadelphia police apparently never got that warning, even after more than 50 years later. But thanks to council today, and Councilwoman Parker in particular, maybe Philadelphia can finally begin to heed that warning. Thank you for your indulgence.
Thank you, Thank you so very much for your testimony, all of you. My colleagues, again, we have Councilwoman Sanchez and then Councilwoman Gim, but I have to ask you while we have you all here. Michael Court brought up something in his testimony that is extremely important, and it helps to put in context a number of issues that are before council now. Councilman Johnson, who led the effort on behalf of council, noting the 14 reforms that council will be advocating for, and we talked about a lot of issues, but Michael Court mentioned Act 111. Act 111. District Attorney Krasner, Mr. Rudowski, Michael Court, Hahn. When you think about the context of Act 111 and its impact on what you see us attempting to address here in the city of Philadelphia, what needs to happen relative to Act 111? I want to get that on the record, and then I also want you to give your perspective on cameras, because, now we've been hopeful that somebody has used their own cell phone camera to catch wrongdoing, right, on the record. Well, if all officers are wearing the body-worn cameras, if that's standard protocol and operating procedure for any officer who is patrolling our streets, does that protect them? But here I say, District Attorney Krasner, Rudowski, and Michael Court. I've also read some data and heard some people to say, Sherelle, you think body-worn cameras are going to help, but they don't help. And they're not going to reduce any of the police brutality, abuse of power, or authority. So I've got to hear it from legal professionals in the city who I respect and want you to go on record about those two issues. Body-worn cameras, Act 111, Rudowski, Krasner, Court, and Hans.
So just let me take a minute. I'll address both those quickly, and then pass the mic. Act 111 is a terrible statute. It prevents, as we know, over the years, even when the police commissioner lawfully terminates a police officer, we find that the arbitration process puts back 70, 75, 80% of those officers, even when there's a full record of that. That act ought to be changed. In the meantime, I don't think Harrisburg is about to do that, but I think the mayor of the city of Philadelphia, in collective bargaining with the FOP, has to push that issue. It's a collective bargaining issue. And for years, I think elected officials in this city have thought that the police union is so strong that they didn't want to challenge them on any of that. I think the union today is more of a paper tiger. And in the era in which we're living, the government of Philadelphia has a duty in collective bargaining with the FOP to remedy, to make changes. Nobody wants to deprive them of due process. If they've been fired illegitimately, they should have a right to some access. The burden ought to be on them. It shouldn't be a final matter with arbitrators who routinely reinstate officers who commit egregious acts. So that's what I would say on that. On the body-worn cameras, look, it's helpful in some situations. The more video we have, the more information we have. I think that's helpful. It's helpful to the prosecutor for sure. It's helpful for all of us to see what goes on in the streets of Philadelphia. It often shows that what people say are not correct. And so I am an advocate for that. On the other hand, it's not, a be-all and end-all. The department's got to make sure that that's expanded, that officers actually activate them or that they're automatically activated. You've got problems along that line, and that they're reviewed not only in cases in which, there are complaints and so on, but it can often give the police department good reason to think we've got problems in certain areas, right? We can learn from what we see on these cameras. More transparency and more accountability is what we need. To the extent body-worn cameras enhance transparency and accountability, I'm for them.
Got it. But so the District Attorney Krasner?
Yes, I'll try to be brief, Chairperson Parker. So, number one, I think there are very few reforms more crucial than changing the fact that the arbitration process for police officers is a fix. It is a fix. It is the most unfair and useless form of accountability. And the thing that's so ironic is it's applied to the people who are supposed to hold us accountable. That has to change. I think that Professor Rudofsky raises an important point. There's been fear of the FOP for a very long time, but we need to understand who and what the FOP are. There are a lot of wonderful, active police officers in Philadelphia who do some great stuff. They're not really the FOP. The FOP is, the voice of the FOP is its retired membership. 2/3, possibly more, of the members are retired. And this is why their headquarters is up on the border of Bensalem. You walk out the side door, you're in another county, because that's where their retired membership lives. You are hearing the voice of the past. And as Professor Rudofsky said, it is not a powerful voice, as the Inquirer indicated today. One thing that you get by not living in the city of Philadelphia is no votes. So the old political equation, the equation that might have impacted Arlen Specter when he decided he wanted to become a U.S. Senator, or might have impacted Governor Rendell when he decided he wanted to run statewide and get all of these other counties that might not love Philly, that equation is over. And the truth is the leadership of the FOP has not represented its active membership for a very, very long time. The retired membership, frankly, is coming from an era when people knew the words Archie and Bunker. And that membership is 100% white, 100% Republican, 100% pro-Trump, and has virtually nothing to do with a lot of the good, younger, active, diverse members of our police department. So politicians are going to have to realize that, because when someone like me says, excuse me, City of Philadelphia, I want to participate in the negotiations with the FOP because I have a significant number of employees in my office who are FOP, maybe this time they'll say yes. When I did that last year, I was told, no, you are not going to be at that table. We're not going to let you participate. And it's not just me. It should be people from the community. It should be people from the clergy. It should be all of us, because we're all affected by the deal that we have now, which is zero accountability and an increase in your pay in the middle of a crisis over 1 year. The only good news there is it's 1 year. And that means we all have time to get together, to gather our forces, because the voice of the community, as you said, Chairperson Parker, is being heard, and it needs to be heard in those contract negotiations, and it needs to be heard on 111. I'll just give you 2 sentences on body-worn cameras. They are essential. Even though they are not perfect, they are absolutely essential in the same way civilian video is essential. We need more of them, and we need fewer excuses for keeping them off. Thank you.
Thank you so much. And listen, they just sent me a note. Listen, I've got Councilwoman Sanchez. Are you on?
Yes, I am. Thank you.
Councilwoman Sanchez, Councilwoman Gim, and then Councilman Derek Green.
So I'll be brief. I want to thank you, Chair Lady, for this conversation. My question before I heard David and RDA and then Michael Cord, I need time to debundle all of what was said, but I think it's important. I want to thank everyone. I think this is an important discussion. The opportunity for voters and others to participate at this particular time is hugely important. So I guess my question is going to be to Marcel, Pratt, and to Vanessa, because I don't want folks listening to this hearing to think that the mayor, to everyone's point who has said the mayor understands how difficult this has been. What is the current directive as it relates to this? And what are they doing around the training and the response to what the mayor has publicly acknowledged as a problem to the department? And whether they can answer that right now or submit it in writing, I think it's hugely important, because again, I just want to get that on the record, and I have to debundle some of this stuff. And as it relates to Act 111, my question is, because in Philadelphia we've learned that we can't always wait for the state, what is it about the selection of the arbitrators in particular? Because I think the criteria, the one thing we can control is one is the law, and then who are the players? Is there something that locally we can do about who the players are in their selection that may help us move this along until the act is totally reformed? Thank you.
Thank you, Councilwoman Sanchez. Marcel?
Yeah, sure. Good afternoon, everybody. Marcel Pratt, City Solicitor. Thanks for the opportunity to answer some of those questions. I was not scheduled to testify today, but because of the importance of this moment, I decided to jump on and just be on record to say that I support the elimination of unconstitutional stop and frisk, including the targeting of Black men and other members of protected classes. We know that the truth is that some police do target people of color, particularly Black men, for stop and frisk. And I think if you deny that, you're intellectually dishonest or something else. It's easy to corroborate. The supporting empirical data, anecdotal data, and as we saw earlier, some of us can do it through personal experience. And I also want to say I agree, Councilman Parker, with your synopsis of the problem when you started the hearing and some of the confusion around the meaning of stop and frisk was one of the most concise explanations I've heard. And I do want to make sure we have the opportunity to explain it in the same way to the public in the future. And I also want to acknowledge I wanted to be on because of some of the legal luminaries that we have in this virtual room who've done this work all their lives. Michael Cord, Dave Rudofsky, Larry Krasner. And so just to turn to some of the questions, on the process itself, we can certainly provide something in writing. And I have Craig Straw, who's first deputy city solicitor, who has worked on the Bailey case from the beginning. And I think he can quickly go through some of the disciplinary measures that have been put in place coming out of the Bailey litigation. But just to answer your question on Act 111 and the arbitrators, I do think the arbitrators are a problem, right? To be an arbitrator, you have to have some qualifications defined by the American Arbitration Association, but you don't have to have a tie to Philadelphia. You don't have to be a lawyer, right? There are a whole host of qualifications and skills that I think arbitrators could have to make them better arbitrators. And so one of the things that we want to explore through the collective bargaining process is a way to make sure that the arbitrators are more diverse, that they have ties to Philadelphia, that they are folks who represent our communities. And so that is something that we're going to push for. But I do want to say just one last thing about Act 111. We do want to change the system. We do want to eliminate structural racism. But I want to be careful about how we talk about Act 111 because Act 111 now is part of that process, right? It's now part of the problem. So, we can talk about collective bargaining all we want, but we have to change the process that's outlined under state law. So I don't want us to lose sight of that. But we can certainly provide more in follow-up. I know, I've said more than I said I was, but I want to turn it over to Craig just to go through quickly some of the details around discipline and other training measures that have been put in place.
Thank you, Council. Thank you, Marcel. Craig Straw, First Deputy, City Solicitor. I've been actually working on the Bailey litigation since its inception. I've worked with Mr. Rudofsky, the ACLU, the federal courts. Provost Joanne Epps was the court monitor for a long period of time. We worked with her. One of the things talking about discipline and accountability, and I think that's the issue of the day in trying to resolve and sort of eliminate unconstitutional stops is accountability. We've talked about this with the courts, police department. Recently, in the last quarter of 2019, actually reassigned 7 supervisors to the audits and inspection unit, which is the unit responsible for reviewing the 7548As. When I think, Hans, you were talking about the audit system being separate from the discipline system. This is the audit system is not a disciplinary system, but the discipline now resides with the audits and inspections unit, which does audit or a portion of the 7548As. So they've reassigned 7 supervisors. We've done extensive training of those individuals on sort of the standards that are required to meet reasonable suspicion. There's now a system in place that when the audits and inspection unit is reviewing 7548As, if they come across officers who are non-compliant in the description, i.e. the description of the incident doesn't have a reasonable suspicion for the stop, that officer will begin a progressive discipline process that starts with a verbal warning. The next incident goes up to a written reprimand, and then there's additional potential suspensions on the third violation. Probably the key to this progressive discipline process is that it doesn't just impact officers, supervisors who are responsible for reviewing the 7548 A's to make sure they have reasonable suspicion. For supervisors who fail to catch those kind of forms, they also will be subject to the disciplinary process. Once an individual is identified as having been non-compliant in the description, i.e. having done an unconstitutional stop or approving an unconstitutional stop, that individual for the next 3 quarters will have their forms reviewed to determine if there are additional violations. Those additional violations will become cumulative.
Hey, Craig, I want to say this, and I appreciated that question, Councilwoman Sanchez and Marcel. I want to note for the record and for the benefit of the listening audience that Mayor Kinney has been extremely clear about the fact that all of the reforms that are on the table now, especially those that are applicable to 111, that he is supportive, number one, of amending and changing Act 11, and also using collective bargaining as a vehicle to address as many of these issues as possible. And Richie Laser from the administration, along with you, Marcel, and others, have communicated that. So, Craig, thank you for getting that on the record. Councilwoman Gim, she has yielded her time to Councilmember Green. Councilmember Green, are you available? Okay.
Yes, thank you, Madam Chair. And I would be remiss in not saying, although it's Friday afternoon, it feels like Sunday morning, and I'm in the radio courtroom with my brother, Michael Cord. And it's a pleasure to have this conversation, as well as having my other fraternity brother, legal scholar, Marcel Pratt, on the call as well. And during our budget hearings, I was asking him questions about qualified immunity. And since we have David Radowski here on the call, I just want to ask him a question about that within this context of unconstitutional stop and frisk. And so many of the issues that we've seen in our city come from unconstitutional stops and frisks. So, as you know, Mr. Radowski, qualified immunity is a legal doctrine in United States federal law which shields government officials from being personally liable for discretionary actions unless they're performed within their official capacity, unless those actions clearly violate established federal law. And so my staff has been able to do some research, and there has been some federal cases in the Third Circuit where qualified immunity did not attach to the behavior of local law enforcement officers because they committed violations of 42 U.S. Code Section 1983, which is federal civil rights. So I'm curious, are you familiar with any situations within the Third Circuit where qualified immunity did not attach because local officials, and we're talking about police, clearly violated Section 1983, and then they became personally liable? Because that's one of the issues that's come out of this whole conversation regarding police reform. There's been questions about how police officers could be held civilly liable for their actions, and qualified immunity has been an impediment. However, based on my information, there are Third Circuit case law where if an officer has violated something like Section 1983, qualified immunity would not attach.
Yeah, let me just take a minute. I don't want to take too much time on that. You're absolutely right. One of the big problems with police misconduct, we've talked about a lot of them, is the lack of accountability in the courts. And what the Supreme Court has done is build a web of immunities that protect police officers and law enforcement agencies. So even when, and here's the point about qualified immunity, even when a court decides that an officer has acted illegally, used excessive force, committed a false arrest, whatever it might be, that's illegal under the Constitution, they won't be liable for their acts unless the law was what the Supreme Court says clearly established. And some courts go so far as to say unless these exact facts have been addressed before, what the officer did this time, maybe he didn't know, right, that he was committing a wrongdoing. And so it's often been used to deprive people of compensation for violation of their rights. It means that officers continue to think that they can do what they want with impunity. In the Third Circuit in Philadelphia, we haven't found that to be an overly problematic doctrine. The judges, as you've said, have often said that the officer was on notice. Officer should have known. A stop without reasonable suspicion is illegal, and therefore they're liable. Excessive force is excessive force. It's a problematic doctrine. We've been trying to get the Supreme Court to revisit it. Congress may get involved in that. But it is part of what I'll call judicial door closing that this current U.S. Supreme Court has been engaged in for the past 30 years, of basically keeping people out of court by various legal doctrines. And not only does that deprive them of vindicating their rights, but it sends a message to the police and other government officials. You can basically do what you want and don't be concerned about accountability in the federal courts.
Thank you, Madam Chair. Mr. Radowski, I may follow up regarding these questions. And I know Solicitor Pratt, we had this conversation during the budget hearings. I'll be doing some additional research regarding this issue. Thank you, Madam Chair.
Hey, Councilmember Green, thank you so very much. And you've been very tenacious to addressing it, so you're us informed of it. And if there's anything that we need to be doing to be supportive, please let us know. Listen, I want to say a special thanks to all of you for testifying today. All of this information, what you submitted in writing and what you put on a record in response to our questions is extremely important. It will help to inform on the deliberations that council currently has to undertake in the midst of all that is before us. So we want to say a special thank you to you. And I also want to say to Mr. Rudowski, DA Krasner, and Michael Cord, I also want you all to know that we also appreciate you for acknowledging, although we have a whole a lot of other work to do and a whole lot further we must go, for acknowledging where we have gone on the record, right? And so because that, it demonstrates that we are trying to move in the right direction, but we're nowhere near where we need to be. But I want to thank you for acknowledging that on the record. For my colleagues, are there any other questions for any of us? And District Attorney Krasner, any closing comments or anything from you, sir?
I just want to make sure, and thank you for the opportunity, I just want to make sure everyone is aware that the DA's office is also in support of Councilmember Kenyatta Johnson's bill that is seeking to have a victim services, especially for one of the great gaps that exists, which is victims whose cases are not solved. And we look forward to working further on details with him.
Thank you so very much. Councilman Squilla, I see you on my screen now. Did you have any comments or questions you wanted to make?
I just want to thank everybody for their input on this matter, how important it is, and knowing how to move forward and how we let people know to start building the trust within government and within the force to make people realize that, your voices are heard, and we are doing the best we can to make sure we implement positive implementation of rules and regulations to move forward. And also what DA Krasner just said about the victims of these crimes, how important it is to make sure that they know they have a place to go and they're not forgotten and that we will stand up for them. So thank you.
No, thank you so much, Councilman Squilla. And that will end this panel. Let me just get to look for 208. Okay. Thank you so very much to this panel. Because there is no one else here to testify, or let me ask, is there anyone else here to testify on Bill number 20076 or Resolution 2008? Hearing none, that will conclude this panel. Rachel, where are we now? Okay. Is there anyone else here? None here to testify. Okay, now we have bill number 200208 and resolution number 200216. Am I accurate with my numbers, Rachel?
Yes, you are accurate.
would you please, Chair, clerk call the roll for the next panel?
Yes, we have Shantae Love, Felicia Pendleton, and Alida Garcia. And I believe Councilman Johnson would like to make some opening remarks.
Yes, and I also want to state for the record that Councilman Johnson has written letters of support here from Vanessa Garrett Harley, Deputy Managing Director for Criminal Justice and Public Safety for the City of Philadelphia, along with our District Attorney, Larry Krasner, who also just put his support for the bill and the resolution on the record. Councilman Johnson, are you still here, Councilman Johnson?
Yes, I am, Madam Chair.
We want to recognize you for comments and want to make a public word of thanks to you, Councilman, for leading that letter that was sent acknowledging those 14 issues and reforms that Council is interested in supporting, and want to say thank you to you, Councilman Jones, and Council President for your leadership on that issue.
Thank you, Madam Chair.
Please proceed, Councilman Johnson.
Thank you, Madam Chair. The needs of victims and co-victims of gun violence is an issue that is deeply personal to me. I myself became a co-victim as a young man when I lost my cousin to gun violence. With the support of my family and friends and my faith, I was able to channel the trauma of that experience into something positive, a lifetime of public service. As a result, I feel obligated to try to give a voice to those who are often not heard and overlooked when it comes to the issue of gun violence here in the city of Philadelphia. Over the last several months, the Special Committee on Gun Violence has convened roundtables and hearings on the needs of victims and co-victims, led by our subcommittee members of victims and co-victims of violence. What we heard loud and clear was that the community needs someone within city government whose sole responsibility is to advocate for victims and co-victims. There are too many agencies that have contact with victims and need to do better work working with victims and working with one another. This legislation will answer their pleas by asking Philadelphia voters to add a victim advocate to the city charter. The Office of Victim Advocate will do the following: advocate for victims and co-victims with a special emphasis on those who are impacted by gun violence, facilitate, coordinate, and collaborate between agencies, provide training and trauma-informed practices to agencies that interact with victims, ensure that victims are notified of their rights to help protect their rights, educate the public regarding victim issues, make policy recommendations, establish an advisory board with community representatives and stakeholders to make sure they have a voice when it comes to public policy and advocacy issues around victims and co-victims of gun violence. I believe that we owe it to the victims and co-victims to give them a voice within city government, and this proposed charter change would do just that. Thank you, members of the committee, for your careful consideration. And again, as we address the issue of gun violence here in the city of Philadelphia, we want to make sure that those who are victims and co-victims have a seat at the table. Those who are victims and co-victims also have a voice when we're discussing issues that are germane and have a severe impact on their lives. Thank you very much, Madam Chair.
Thank you, Councilman Johnson, and Shantae Love, Felicia, and Mr. Garcia. Are you all live? Are you here? Are you connected?
Yes. This is a lady.
Yes. Okay, we're going to hear your testimony in this order. Shantae, Felicia, and Alida. Pronounce your first name, please.
It's pronounced Alida.
Alida. Okay, thank you. Please state your name for the record and proceed with your testimony. And we'll begin with Shantae. Oh, okay. Felicia Pendleton?
Yes.
Thank you, Felicia. If you could just state your name for the record and proceed with your testimony.
Felicia Pendleton?
Yes, ma'am.
Well, basically, When I testified at the last hearing, it was so we can get to this point that we are at right now, which is creating a bill that really focuses strictly on victims and co-victims. So often we are like overshadowed by other things that's going on in the city, but very seldomly is a focus on victims and co-victims. Specifically, being re-victimized. Being re-victimized and not having the resources that should be in place for us. I feel like the bill that's being presented today is definitely necessary because we need a central office. We need a central place where, you can go to and they will assist you with all your needs instead of having to go back and forth to the district attorney's office, trying to get someone at the district attorney's office on the phone to answer your questions, to find out who can assist you in your time of need for your grievance situation. Many of you do know, many of you don't know, but my son was murdered, and that's why I'm here. And it was very few people that reached out to me during that time. Just so happened I knew someone, and they contacted Mayor Center. And Shantae came directly to my house, but if it wasn't for someone that I knew that's not connected to anything, I wouldn't have been pointed in direction to Shantae. Mm-hmm. So I believe that the bill should be presented as a voting tool so victims will have their needs met. Thank you.
Thank you so very much, Felicia, for your testimony. Felicia Pendleton is the founder of Moms United by Angels. Ms. Garcia, are you here?
Yes, I'm here.
Thank you, ma'am. Please state your name for the record and proceed with your testimony.
My name is Aleda Garcia. I'm the co-founder of the National Homicide Justice Alliance. First of all, I want to thank you, everyone present here today, for your concern and actions to save lives from violence and to empower and advocate for victims and co-victims of homicide and gun violence in Philadelphia. I want to especially thank Councilman Kenyatta Johnson and Councilman Curtis Jones for leading this important initiative, Joshua Harris and other members and supporters of our subcommittee. And a special thank you to the members of the Victims Subcommittee of the Special Committee for Gun Violence Prevention, Dr. Dorothy Johnson-Spite and Anthony Murphy, who for many months have been listening to testimonies from families of murder victims, victims of shootings, victim agencies and organizations that work with those affected by gun violence and work with them on a daily basis. As the mother of Alejandro Rojas Garcia, who was shot 15 times and left to die 1 block away from the 25th Police District on January 24th of 2015, I'm here to represent his 2 children, our family, friends, and we have had to endure the aftermath of this brutal murder that devastated our family. Like most families of murder victims, we needed a lot of help. And in many ways, during the lowest point of our lives, our tragedy forced us to become self-made detectives and advocates. We needed information, communication with the homicide detectives. We needed help to pay for the unexpected funeral expenses and counseling for our family. We needed support, and so we became advocates to seek justice and get responses from the criminal justice system as we learned about the policies that negatively affected survivors. Even in our time of grief, financial matters had to be resolved and decisions had to be made. As you can imagine, it is a horrific experience. At the time, the social service agency in the East Division was not open, and therefore we received help from other sources as we sought them out. The Victim Services Office from the Homicide Unit came out to speak with me and helped me to fill out some VOCA paperwork. And then a community activist, Roz Pichardo, came to visit. With the 25% increase, as of today, 178 murders, a 25% increase to homicides this year, I hope that when another family is going through this horrific tragedy, that there could be easy access to information and an office for victims to help them navigate services and to mediate any issues that they might have with other government officials and victim services agencies. As a survivor and co-founder of the National Homicide Justice Alliance, I fully support the establishment and the resolution and the establishment of the Office of the Victim Advocate in Philadelphia. There is no other government office in Philadelphia that will specifically advocate for victims and co-victims of homicide and attempted homicide, of which the majority are gun violence cases. Although elements of victim services exist in other governmental offices, the district attorney's office is mandated to represent the Commonwealth. The public defender represents the defendants. But which government agency or government office is the buck stops here office with the authority to advocate for victims directly with the police commissioner, the district attorney's office, and other government entities? So a variety of research projects with numerous disciplines have shown that the consequences and costs of murder can be devastating not only for the victims and their families, but also for neighborhoods and communities. During this difficult time, the cost of establishing a new office may be a concern, but the reality is that violence is very costly. And by providing victims with advocacy information and referral to appropriate services, we may actually save funds through violence prevention and for violence prevention. Funds that need to go into working with trauma and addressing the cost of homicide. There's a sociologist named Dr. Matt Delisi in the University of Iowa who is well known as a specialist in this area. He wrote an article for the Journal of Forensic Psychiatry and Psychology. And what he says that in addition to the psychic toll, murder is also financially costly. The article analyzed state-level data from Pennsylvania to produce estimates of specific forms of violence committed by and against juveniles and adults. Considering medical care costs, lost future earnings, public program costs, property damage and losses, and quality of life losses, the average murder of a juvenile costs nearly $4.2 million in urban areas. And the average cost of a murder of an adult is $3.5 million. The Philadelphia Office of the Advocate will act on behalf of victims and co-victims of homicide and attempted homicides. And will work towards creating greater public awareness, understanding, and advocacy directed towards solutions and collaborations. The office will be designed as a cutting-edge and innovative effort by the City of Philadelphia to implement the latest methods, research-based strategies, and best practices to advocate for gun violence survivors, homicide victims, and co-victims. The Office of the Victims Advocate may also engage with and collaborate with gun violence prevention groups as well as victim service agencies to build community among survivors and organizations with the guidance of a survivor-led advisory board. The proposed office can continually look at how policies may affect survivors and witnesses of crime, who in some cases are also co-victims and survivors as well. As our colleague Shantae says to us often, every case is different and every murder is real. Thank you.
Thank you so much for your testimony, Aleda. To Felicia and Aleda, thank you so very much. Felicia, during your testimony, you said something that a lot of people don't realize, and you talked about having to be victimized twice when supports are not available for those who are on the other side of violence. And so I want to say to you, thank you so much. I know Shantae is not here, but Shantae Love, if you are watching somewhere or if you are listening to us, we want you to know we appreciate the groundbreaking work that you're doing with Amir and you as well, Aleda. And the chair now recognizes Councilwoman Quinona Sanchez.
Thank you, and I'll be brief, Madam Chair. I too also want to thank Councilman Kenyatta Johnson for all the work he's done in getting us together around some common values. As it relates to this work, I want to echo your words to Felicia and Shantae, and I personally want to just, for the record, because this is important, it's groundbreaking, it's historical. Aleda's been on this mission for a very long time, and she's helped me and others really understand the value of some of this work. In East Division, we did not have a victim services office. There was a lot of issues related to that, and these women empowered themselves. And I think you've said this before, you know, the power of government is in the people, right? We're just vehicles and facilitators. And I just really want to thank her for her steadfast, her commitment, her willingness to just educate and take the time for everyone else who was in this position. And, you know, this piece is one component of it, how we set this office up, how we fund it, and how we reflect those values and the camaraderie that these women have established. We look forward to working with all of them. So thank you, Councilman Johnson and Councilman Jones, for listening and for empowering and for creating this vehicle. I think it's hugely, hugely important. And I know for us in our community in the 7th District, the work of Aleda does not go unrecognized and everyone else. So thank you.
Thank you, Councilwoman Quinones Sanchez, for putting that on the record. Chair recognizes Councilwoman Gim.
Thank you so much, Madam Chair. I also wanted to just express my gratitude to Councilmember Johnson for leading on this issue and for the organizing group of relentless women who have stood up for their communities. It's been a journey, as was said before, to get to this point. I'm proud to be one of the members of council to support you. Thank you very much, Madam Chair.
Thank you so very much, Councilwoman Gim. Are there any questions or comments from members of the committee? Hearing none.
I have one, Madam Chair.
Oh, I'm sorry, Councilman Johnson.
Madam Chair, I just want to ask all of my colleagues for affirmative vote, and I appreciate your support. And I also want to take a moment to thank Felicia Pendleton. I want to thank Ms. Aleda Garcia. I want to thank Shantae Love. I want to thank Anthony Murphy of Town Watch, as well as Ms. Dorothy Spider, Mothers in Charge. Madam Chair, sometimes there was a statement where someone said, if you want something done, give it to a woman. And these women have challenged me, they have held me accountable, they have encouraged me, they have supported me to make sure that we continue to make sure that the voices of victims and co-victims of gun violence and violence in general are on the forefront and are a part of our agenda here in the city of Philadelphia. So I just want to personally just thank them just for being supportive of these efforts and most importantly, just making sure we keep this a priority. So thank you very much, Madam Chair.
And Councilman Johnson, I want you to just stay right there for a second. I want to say this for the benefit of the public that is watching right now. Councilman Johnson, you remember there was a time when Philadelphia saw a decrease in the number of homicides and violent crime was down. And then all of a sudden we saw those numbers begin to rise again. And then people sort of, particularly in the electeds, you know, come out of our woodwork and will jump in front of issues, particularly if there's a camera there to be captured. I want to say publicly, thank you. You've been a part of this work, and this has been a part of your mission because of your personal experience. But when I think about Peace Not Guns and that you did that when no one was watching, but because of what you experienced in your family, your work, and you were advocating for this before you even became a member of council. I remember when we sat near each other in the Pennsylvania General Assembly, and you would be leaving to get back to Philadelphia so you could do your work with Peace Not Guns. I want you to know we don't take that lightly. You are no Johnny come lately to this issue, and I want to say thank you on the record for that.
Thank you, Madam Chair.
Thank you. If there's no one else to testify on the bill whose name has not yet been called, Hearing none, Rachel, will you call the first panel that we have to testify this afternoon on bill number 200328? And before, as you call the panel forward, I would like Council Member Gim. Are you still here, Council Lady?
Yes, absolutely, Councilman Chair.
Councilwoman, I wanted to recognize you so number one, I want to say to you on the record, and I want the public to know, Councilwoman Gim has been sending me text messages throughout this entire hearing, thinking that we were not going to meet our time guidelines. But as you can see, Councilwoman, I do know how to manage time. So thank you for your encouragement via the text messages. And Councilwoman, I want you to give opening comments on this piece of legislation that you worked so hard for.
Yes, thank you so much, Madam Chair, and certainly wanted to just yield my time because I think the testimony of those individuals who spoke today was just so much more important. And this is an important moment both to talk about the need for true justice and reform to end unconstitutional practices and abusive practices like stop and frisk, to uplift crime victims and make sure that they have a single point of contact and an office that's advocating for them. And I hope that this bill that we talk about will be in that similar vein. So thank you. So we are here to talk about the world, a new world. As we look towards reopening Philadelphia, we owe it to ourselves and to each other to protect the essential workers who have kept our country running. Tonight is about the workers who got up every day to keep our grocery store shelves stocked, our hospitals and nursing homes staffed, our buses and trains running, our streets clean. It is about home health care aides, social workers, and so many more people who kept Philadelphia going. For those folks who showed up for us at a time when so many of us were fearful about a world that became rapidly unhealthy and unsafe, today is for you. This is for all the workers who had sleepless nights and tough conversations trying to balance their own health and the health of their families and the obligations to the communities that they served. As our city cautiously reopens with a looming threat of second waves on the horizon, one of the most important and basic things we can do is to ensure that any open workplace is a safe workplace. I and my colleagues on this body have been moved to action by the stories of workers who have fought for better and safer workplace conditions, the urgent cry for PPE and sanitation, and basic testing and quarantine when the first terrifying symptoms reveal themselves. We are moved to action because of a COVID town hall with 1199C healthcare workers who spoke of being called into work despite being under doctor's orders for quarantine for COVID positive symptoms. We are moved to action by grocery store workers and UPS warehouse employees who had to negotiate with their employers for protocols around essential cleaning and basic access to sanitation and help. We all know that the federal government has failed time and time again to establish appropriate workplace protocols. In fact, the Trump administration has yet to issue any COVID-19 specific OSHA standards. So this work has to be collectively addressed at the workplace, and that cannot happen effectively if employees are threatened and retaliated against for raising important issues about the public health. Before you today and before this committee today is consideration of bill number 200328, the Essential Workers Protection Act, which is designed to protect the public health by protecting workers from employer retaliation for addressing conditions which violate public health orders, thereby mitigating the risk that workplaces become hotbeds of COVID spread. I want to thank the 10 co-sponsors of this bill, Council Members Squilla, Johnson, Jones, Quinones-Sanchez, Heenan, Gautier, Brooks, Thomas, and Gilmore Richardson. I also want to thank the 25-plus labor and community organizations who are supporting this legislation, including Unite Here, our hospitality workers, Teamsters Local 623, our UPS drivers and warehouse workers, sanitation workers, SEIU Healthcare, PASNAP, BMW ED Teamsters, ASME 1199C, and Transit Workers Union Local 234, and Teamsters 115. This bill has had numerous amendments, and we thank our partners in this effort to ensure that this is a bill that is workable, enforceable, and establishes a basic floor for protection. This bill is about protecting lives as we try and forge a path ahead in an uncertain world. It poses no threat to the many employers in our city who are abiding by state and local regulations and it is entirely consistent with current state and local anti-retaliation laws. I'm glad to have the support of the Kenney administration. I am grateful for the support of our community organizations such as One Pennsylvania, Maternity Care Coalition, and so many others. And I'm committed to working with our labor office to ensure that this bill is implemented in a way that's fair for all. We owe it to our workers to protect them from retaliation. When they are safe, so are we. Madam Chair, I yield my time.
Thank you so much, Councilwoman Gim. Mr. Laser, we see that you are connected. Are you ready to proceed?
Yes, I am.
Please state your name for the record and proceed with your testimony.
Thank you. Good afternoon, Chair Parker and members of the Law and Government Committee. My name is Richard Laser. I'm the Deputy Mayor for Labor. I appear before you today to testify in strong support for Bill number 200328. This bill is an anti-retaliation bill that offers valuable and timely protections to all Philadelphians as we enter the recovery phase of the COVID-19 pandemic. The measures we have all taken as a city have made it possible for businesses to reopen and for people to finally have the opportunity to go back to work. This started in earnest at the end of last week when Philadelphia officially moved to the yellow phase and will only continue as more businesses reopen. While we look forward to some additional freedoms from the stay-at-home order, we also know from the first-hand experience of essential employees during the height of the pandemic that there are legitimate challenges and safety concerns with running daily operations in a way that maintains safety to both the public and the workforce. Bill number 200328 addresses those concerns by providing workplace protections for employees against retaliatory actions, both for the disclosure of information related to employer noncompliance with such orders and for refusal to work under unsafe conditions caused by the noncompliance. The city worked hard to continuously publish and disseminate up-to-date workforce safety guidelines for all industries, and it is our hope and our expectation that businesses within Philadelphia will follow those guidelines. While we are confident that most employers will be in compliance, this bill will ensure that all workers receive the same protections. Additionally, it has been well documented that in terms of health impacts, mortality, and economic security, the COVID-19 pandemic has had a disproportionate impact on people of color. Recent studies on the pandemic show Black workers in particular are twice as likely to have been retaliated against by their employer for speaking up about health concerns at work, among other concerns as well. As we move forward into recovery, it is critical that workers communicate with their employers and that their own health and safety in the workplace. We believe this anti-retaliation bill is an important tool we can use to support our communities. We support this bill as amended, and I look forward to answering any questions you may have at this time. Thank you.
Thank you so much, Mr. Laser, for your testimony. Are there any questions or comments from members of the committee? I'm looking in the chat box now, but I don't see any. There being none, Rachel, will you please call the next panel to testify on this bill?
Yes, we have Pat Eiding, Charles Carrington, Irene Tung, Nico Kwiatkowski, Richard Hooker, and Korean Holloway.
Good afternoon to each of you. I see my good friend Pat Eiding, so I know that you are connected. We will go in the order that Rachel just announced. We'll start with Pat Eiding. Please state your name for the record and proceed with your testimony. Why don't you unmute for me, Pat? Unmute for me.
You'd think right now I'd be better at this, but thank you, Chairwoman Parker. My name is Pat Eiding. I am the president of the Philadelphia Council of the AFL-CIO. We like to say we represent 150,000 working families, but we also like to work for all working people. And I thank you for allowing me some time today. I know this is a crazy world we're in, and I appreciate the time that's being spent on these bills that I've just listened to and support. I will say that respectfully, I've submitted a letter
to all the people, the council people on this panel, on this committee rather. And if I may, rather than reread that letter in support of this bill 2002328 rather, I'd like to go off the record a little bit of the presentation of my letter and speak what I know to be true. When we've gone through these problems, there's been so many people, workers of every area that had to step up, whether they're collecting your trash or taking care of your grandparents in the hospital. And they stepped up at a time where many of them didn't step up when they weren't getting what they needed. And I know this is a fact because, unfortunately, without putting blame on any particular person, this country allowed another country to be the only source of safety, PPE, if you will, for the workers who are out there putting their life on the line every day, and their families, quite honestly. I know that nurses were being asked to use the same mask over and over, the same equipment over and over. I know that nurses were being chastised for bringing their own N95 respirator in because they were looking that they were making a statement. They weren't. They were just trying to protect themselves and their families and the people they were working with. So, coming from the world of asbestos, I know what a little bit is. There is no little bit of asbestos. 1 fiber or 100 fibers, nobody really knows. So the right to somebody to be able to protect themselves and their family, and as we say in the labor movement, be able to go home the way they left their house in the morning without bringing some sort of a disease or virus home, they should be able to stand up for their rights, and they should be able to stand up without the threat of being fired. I know you must have read in the paper, probably very early in this terrible time we're going through, when a registered nurse in New Jersey, because she wanted to use her N95 respirator without the hospital being able to afford to give them one because they couldn't get them, whatever the reason, she was fired. And that's what this is all about. We shouldn't have people who are protecting us and putting themselves on the front line be afraid to stand up when their life is in danger. And so I think this goes a long way for a piece of ordinance that we've had for a long time that needs to be fixed. And so I stand here as strongly as I can from the labor movement to support this piece of this ordinance to make sure we can protect those folks who protected us. Thank you very much.
Thank you so much, Mr. Pat Eiding, for your testimony. Mr. Charles Carrington, are you there?
Good evening, Madam.
Thank you, Mr. Carrington. Please state your name for the record and proceed with your testimony.
Good evening. My name is Charles Carrington, and I'm the president of Athens Local 427, which represents nearly 1,100 sanitation workers for the city of Philadelphia. I am speaking to you today to urge you to pass Bill 200328, which would guarantee that all employees follow public health and safety orders, and that the workers, like my fellow sanitation workers, can report public safety concerns to your managers without risk of being retaliated against. I first want to thank City Council for its support, and especially Council members Parker, Johnson, and Gim, who stood with us in Love Park on Tuesday to bear witness to the testimony about the conditions we have been subjected to over the course of the pandemic. It's unacceptable, and we need your help now more than ever. The fact of the matter is that we are frontline workers of this crisis, and we have been for the whole time. We service every house every week. We are exposed to enormous risk each day that we go out and provide the cleanliness to this city. As the city further puts into place health and safety standards, we have to be protected. And when my members report an unsafe act or hazardous conditions, he or she should be able to report this issue without fear of discipline or retaliation. There is no one standing by to make sure that we receive necessary health and safety protections. We are our own advocates and our only shields between ourselves and the virus. The least City Council can do is to make sure that we are not harmed if we take the stand and report unsafe conditions. I thank you for your time and your continued support. We will have to continue to work together to ensure that all jobs in Philadelphia are safe and healthy, and I look forward to the passage of this bill as the first and necessary step. Thank you.
Thank you so much, Mr. Carrington. It's Irene. Irene, are you there? The researcher with the National Employment Law Project?
Yes, I am.
Okay, I can see you now, Irene. Irene, please state your name for the record and proceed with your testimony.
Irene Tong. Good afternoon. My name is Irene Tong, Senior Researcher and Policy Analyst at the National Employment Law Project, NELP. NELP is a nonprofit, nonpartisan research and advocacy organization specializing in employment policy. We are based in New York with offices in Washington, D.C. and throughout the country. We partner with federal, state, and local lawmakers on a wide range of workforce issues, including health and safety protections, access to unemployment insurance, and strengthening workers' rights to speak up and organize in the workplace. Thank you to the members of the committee and the chair for the opportunity to testify in support of this important bill. At NELP, we have long known that worker health is public health, a fact that the COVID-19 pandemic has underscored again and again. With this legislation, Philadelphia can lead the nation in guaranteeing workers the strong protections from retaliation that they urgently need. Such protections will not only help ensure the health and safety of workers on the job, but also play an important role in containing the future spread of COVID-19 in Philadelphia and beyond. I'm here today to share the findings of a national survey of workers that NELP conducted recently, the results of which show the urgent need for the protections embodied in Bill number 200328. From May 8th to May 11th of this year, NELP conducted an online nationwide survey of over 1,000 workers to determine whether they are concerned about health and safety risks related to COVID-19 at their workplace, and if so, whether they feel comfortable raising these concerns with their employer. I've included the data brief summarizing the survey results with my written testimony for your reference. A majority of the workers surveyed indicated that they have concerns about the risk that they, other workers, or the public may be exposed to coronavirus at the workplace. Just over a quarter of the workers surveyed, 27%, were able to raise any concerns they had with their employer and received a satisfactory response. However, for every worker who raised concerns and was satisfied by their employer's response, another worker had unaddressed concerns, either because they raised the concerns to their employer but were unsatisfied with the response, or because they did not raise concerns for fear of retaliation. Among Black workers, the rates are even higher. Black workers were both more likely to have concerns and were twice as likely as white workers to have unresolved concerns, with more than 1 in 3 Black workers reporting that they had either raised concerns to their employer but were unsatisfied with the response, or that they did not raise concerns for fear of retaliation. Moreover, 1 in 8 workers overall reported that their employer may have retaliated against them or another worker for raising concerns about working conditions related to COVID-19. And Black workers are more than twice as likely as white workers to have seen possible retaliation by their employer. In addition to retaliatory action for raising concerns, respondents indicated that they feared job repercussions for refusing to work to protect their health or their family's health. Overall, 56% of those going to work did so even though they believed they were seriously risking their health or another family member's health. Of those, 38% of workers reported going to work because they were afraid their employer would penalize them if they didn't. And once again, among Black workers, the rates are even higher. 3 out of 4 Black workers have gone to work even though they believed they may have been seriously risking their health or the health of a family member. Results are broadly consistent with the results of a recent Washington Post Ipsos poll of more than 8,000 adults nationally that asked similar questions. That poll found that 68% of those working outside of the home are concerned about the possibility of getting sick. And the poll also found higher rates for Black and Latinx workers, with roughly 7 in 10 saying they were worried about getting a household member sick if they are exposed at work. Unsafe working conditions and the legitimate fear of retaliation that workers face blowing the whistle on them endangered not only the workers themselves, but their families and communities. Many of the people contracting COVID-19 are frontline workers who then spread the virus to their family members. As has been widely reported in Philadelphia, Black and Latinx people have disproportionate COVID-19 infection rates and experience more severe outcomes when they are hospitalized. Our research suggests that virus transmission in the workplace may be exacerbated by employer repression, and that the disproportionate impact of COVID-19 on Black communities may be related to greater exposure of Black workers to repressive workplace environments. Bill number 200328 empowers workers to improve their workplaces and to protect themselves, their families, and their communities from the spread of COVID-19. It prohibits employers from retaliating against workers who refuse to work because of good faith concerns about unsafe conditions or who blow the whistle on these unsafe conditions. Equally important, it prohibits employers from retaliating against workers who disclose information about workplace hazards. Protecting such whistleblowing is especially important because OSHA and the federal government relies heavily on workers coming forward and filing complaints. Yet while OSHA nominally bans retaliation against workers who speak up, in reality, such protections are completely unenforced under the Trump administration. Moreover, the OSHA whistleblower protection includes no private right of action, further limiting its enforcement, especially since the Trump administration has slashed OSHA enforcement funding and staffing, including for the protection of whistleblowers, to its lowest level in 45 years. For this reason, it is critical that cities and states, like Philadelphia, step in to protect workers. By protecting worker whistleblowers and workers who refuse to work under dangerous conditions, and by establishing a private right of action for enforcing those key rights. Bill number 200328 will enable workers to be the first line of defense against COVID hazards in the workplace as Philadelphia's economy reopens. Thank you so much.
Thank you so much for the testimony. Nico from Pennsylvania. Nico, are you still on?
Yeah, I'm here. Can you hear me?
Yes, we can hear you well, Nico. Nico, please state your name for the record and proceed with your testimony.
Sure. Nico Kwiatkowski. Good afternoon. My name is Nico Kwiatkowski. I'm a resident of Philadelphia. I work at Mom's Organic Market in Center City, and I'm a member of 1PA. First, I want to thank the council for allowing this dialogue and for considering this bill. I'm speaking to you today as a person fulfilling a variety of roles during the COVID-19 pandemic. I'm an essential worker, I'm a whistleblower, and I'm also a resident of Philadelphia. The protections offered through this bill would directly affect my day-to-day life in all of these respects, as it would for countless others across our city. As an essential worker, I've grappled personally with the impossible choices many of us now face, weighing risks to my health against risks to my career and financial security. And while I continue to work full-time, I'm acutely aware of the danger this work entails. I'm also aware that as a lower-level employee at a grocery store, I have very little say in the day-to-day operations, protocols, and practices that comprise my typical workday. These are choices made by my managers, people who have no training in matters of public health, as well as by our company's executive leadership, people who have little professional interest in anything beyond maximizing sales. It's a feeling of powerlessness, to say the least. As a whistleblower, I've grappled with another impossible choice, weighing risks to public health and safety against risks to my career and financial security. In the early days of the pandemic, several coworkers and I initiated conversations aimed at establishing safety protocols for our store. We were met initially with resistance, hostility, and disregard by our company's leadership. As our voices grew louder, one of my coworkers was fired and many more were reprimanded. I saw directly how these disciplinary actions had a chilling effect on our workforce. Many people quit, others took unpaid leave, and the rest resigned to their fate and hoped for the best. It was only through the support of fellow workers, 1PA, journalists, legal experts, and a community of friends and family that a group of coworkers and I felt empowered to raise the alarm publicly. And it is only through this same community of support that our store is safer today and that I remain employed, at least for now. As a resident of Philadelphia, I've applauded the public health orders mandated by the state of Pennsylvania for essential businesses. But my experiences at work have shown me how some businesses prioritize profits over compliance. To put it simply, executive orders alone are not enough. Only essential workers can provide a window into the day-to-day operations and sanitary practices of essential businesses. And without adequate protections, would-be whistleblowers face tremendous risks for their public health advocacy. These risks become all the more clear in light of recent studies, which show that workers of color are more likely to suffer retaliation than their white counterparts during the pandemic. And with the pandemic still looming large in Philadelphia, providing protections like those proposed in this bill cannot wait.
As an essential worker, as a whistleblower, and as a resident of Philadelphia, it's clear to me that protecting frontline workers from workplace retaliation is the most fundamental way our civic institutions and leaders can support public health and safety during the pandemic. When workers are protected, we will speak out to defend public health when necessary, and our voices will lead to safer workplaces, safer businesses, and in turn, a safer Philadelphia. Thank you for your time and your consideration.
Nico, thank you for your testimony. Now, Corrine Holloway from Unite Here. Corrine, now if I mispronounce your name, help me. Corrine Holloway?
Yes, Corrine Holloway.
Okay, Corrine, when I'm reading it, I couldn't tell if it was a hard C or a soft C, right? So people call me Correll, but it's okay. So it's definitely Corrine. So that's good.
Yeah.
Hey, Corrine, listen, state your name for the record and just proceed with your testimony, okay?
Okay. My name is Corrine Holloway. I am a recording secretary of Unite Here, Local 274. I've been a hotel worker for the last 45 years. I thank God for my union because it gives me the freedom to speak my mind. I am one of the few workers at my hotel who haven't been laid off. With the virus, it had changed almost everything, how the hotel operates. I'm happy to still have my child, but it is scary going to work these days. Most of the room in the hotel are being rented by a group of kids. They're like 18, 19 years old. And we have a lot of issues making sure that they wear their masks. I had one woman who came out of the hotel room and asked me for extra towels. She was not wearing a mask, and her husband followed out behind her. And she told him to go back inside, and she explained to me that he had the virus. Neither one of them had a mask on. And we also had a problem with a few of the managers that I had to report because they wasn't wearing a mask. I'm sorry, there's some noise going on the outside. I hope you can hear me. And for the most part, they just stay away from the guests and hide in their office. So my GM, I haven't seen him in the last 3 months because they stays in the office. HR, you don't see them. And so my coworker and I, we try to make sure that people have a mask. So sometimes when you see somebody without a mask, you'll ask them, can they put their mask on? So the manager gets really upset about that. And so I would be so happy if this bill could pass. Because thinking about it, I was here during Martin Luther King time. So yeah, pretty old. So, but anyway, thank you so much.
And Ms. Kareem, thank you so very much for your testimony today. You stand on the shoulders, Ms. Kareem, and let me just say it for the record. For those who don't know, if you've ever seen the movie The Help, if you've ever seen that movie, that's whose shoulders you stand on, Miss Kareem. But the women who help to keep households going and businesses going, but they never get recognized. The men and women that Councilwoman Maria Quinones Sanchez acknowledged in her Domestic Workers Alliance bill. You stand on the shoulders of some women who were strong enough to speak. So thank you so much for your testimony today. We greatly appreciate you. Is Richard Hooker here? Are you here, Richard Hooker, the Secretary and Treasurer of Teamsters Local 623? Richard Hooker, Jr.?
Yes, Madam Chair, I'm here.
Thank you so much, Richard. Richard, if you could just state your name for the record and please proceed with your testimony.
My name is Richard Hooker, Jr. I'm the Secretary, Treasurer, and Principal Officer of Local Teamsters 623. this bill will be a great addition to just protecting essential workers. Many employers are ignoring regulations and endangering and the workers that I represent at UPS, they fail to provide members with hand sanitizer, face masks, and properly clean their facilities for weeks. After the CDC guidelines and after pressure from the members, pressure from myself, pressure from other members of our board, we actually had to go to the news media to get them finally to sit down and protect our workers. Even after the mandate of essential workers had to go out and still deliver in this COVID-19 pandemic for our workers to be protected. And it's one thing for our workers to go out and make sure that other families have their necessities, but we need to make sure that we provide protections for the workers providing those necessities. The workers that were deemed essential, like our members at UPS, and the workers that stock the shelves, and hospital workers, and all these workers who are on the front line, they need these protections because the boss is not going to provide them on their own. So we need city council. We need to make sure this gets passed because our workers need to go. We need to know that we have their back. Is the boss think they're disposable? So we need to make sure that they are essential, and not only that, we need to make sure that the way they leave home, they go back home the same way. Because to the boss, the workers are disposable, but to our families, you're everything. So we need to make sure that we protect them. And all the people that want to speak out when they see unsafe conditions during this pandemic, we need to protect them so when they do speak out, they still have a job to go through the next day. So finally, I just hope that council adopt this and whatever help that we can provide on our end, we'll make sure that we can do that. Thank you so much.
Thank you so very much, Richard. We really appreciate your testimony. So is Sylvia? Sylvia, are you here from 1199C, Sylvia? Councilwoman Gim, that is the additional name that you provided to us, isn't it?
I think so. We can check, but if she doesn't come on, I think we can.
Okay. So, Sylvia, we want to just call you. Just, Sylvia, are you here? Just in case you're having difficulty. If you're trying to unmute, I believe it's *6. Is it *6, Lonnie?
Yes, it is *6.
*6.
I'm back, Council, Madam Chair.
Yes, ma'am. Is she still here, Council Lady?
I just got a text from Salima at 1199. Let's go to the next speaker, and then I'll try to get her back on. She's having trouble.
Okay, but is it McGillen? The next speaker who is live on the line. Okay, so that was it. Well, okay, that's it. Now, Councilwoman Gim, I'm being told by Rachel Meadows, our clerk, that is it for those who are on the line who are scheduled to testify. I want to ask, are there any questions or comments from members of the committee? There being none. Councilwoman Gim, you wanted to make some comments. Please feel free. Proceed.
Well, first of all, I wanted to say thank you. I wanted to express my incredible gratitude to the essential workers whose faces that we actually get to see. You know, I think we throw out the term essential workers and we say, you know, praises, and we can send commercials and gratitudes and platitudes. But the reality is that if they are truly essential, then we have to value them as such. And I think what we heard from wonderful people like Ms. Holloway and President Hooker, President Carrington, who are working with sanitation workers and warehouse workers, with Nico, who is working with grocery store workers.
Hi, is Nico here?
Who's speaking?
It's Shanae Gardner from Helen Gim's office.
Shanae, I think you're unmuted.
Good. Are you guys still trying to speak? I didn't get a response back. I know you guys were having some connection issues.
You're unmuted, Shanae.
Thank you, Councilwoman.
We may be trying, but if we'll do our best, Madam Chair.
Okay, go ahead, Kay. Go ahead.
Yeah, so I think what we heard is that these are public health orders that are mandated by the state and local governments. But unless we put some teeth behind it, we cannot have them, they will not be enforced. I mean, that's the reality. And that many of these workplace spaces, as we've heard from grocery store workers and warehouse workers and our sanitation workers and our SEPTA workers, is that we have to negotiate them on the workplace site. It is an honor to be with so many workers who showed up when many of us had the privilege to stay at home. And it is not lost on me what Dr. Tung said in the research that they did, which is that 1,400 Philadelphians have died of this horrendous virus. If you take us against the largest cities in the country, we rank second behind New York City. So, you know, and the racial disparity that has been occurring around COVID, and the fact that our Black and brown workers are front line, that they are not paid adequately. We have the lowest minimum wage rate in the country. We do not guarantee paid sick leave at the statewide level. They deserve more. And I know that our council body and this committee and your leadership, Madam Chair, supports that. And I'm just so grateful that we had a chance to hear from so many people who are doing the right thing. They are not only protecting the public safety for themselves and for their family members, they're doing it for all of us. So thank you, Madam Chair.
Thank you so very much, Councilwoman Gim. And listen, Council Lady, we want to note for the record that as it relates to Bill number 200328, that there were written letters of support that were also presented from Unite Here and other labor unions and organizations, and they include 1199C, Local 115 EWPA, PASNAP. And there was also one letter written raising concerns from Temple Health. Councilwoman Gim, we will make sure that the stenographer gets all of those letters that were submitted in writing, and we will get those on the record. Since there are no other questions or comments from members of the committee, there being no further questions from members of the committee and no other witnesses to testify, I will ask if there's anyone else present in the hearing whose name we have failed to call and that wishes to offer testimony on any of the bills being considered today. Hearing none, I want to thank all of the panels and witnesses for their participation today. We value your opinions. I now invite all panels and witnesses to please disconnect from the meeting before we go into our public meeting. We will now pause the proceedings briefly as multiple participants have to leave the meeting, and we don't want you to have to hear all of the hanging up and all of the other stuff that happens technically. So we are going to offer a brief pause as multiple participants disconnect from the meeting and only members of council are present. And Lonnie, you will let me know when it is time for us to proceed.
Yes, I will. Thank you.
want to thank you for your COVID town hall. I think some of the stories that came out, and if you want to share any of them very briefly with our committee, there are a lot of the reason that moved me and many others to action, because we can't listen to those stories and not do something about it. If we say that we value our healthcare workers, you who showed up to take care of our seniors and elderly when we can't even go into the nursing home.
Right.
Your family members, your membership took care of family and became their family in the most terrifying and dangerous of times. But it wasn't right what we heard on that from that COVID town hall. And I'm happy just, if you had a few moments to just share one or two of those stories, just to make it clear.
I'll be very brief. And what you're referring to is that Centennial Nursing Home in West Philadelphia. Our members are dying, and that's just what it is. Our members are being told to come back to work with, hey, you're still positive with COVID. You're not having that full availability to stay home for 14 days. I have a member who I was trying to get on for you guys tonight who is paying over $400 a month. She was on a ventilator for over a month, tested positive of COVID-19, and is now paying for her own health insurance. She works at St. Monica Nursing Home in South Philadelphia. She's paying $90 a month for her oxygen. So I'm looking for some financial assistance for her. It has been hell. That our members is bigger, and me and Helen talked about this, is bigger than a labor management issue. This is a humanity issue. And our members, a lot of them are making life decisions because they have to work. They got to take care of their kids. People are leaving their children at home unsupervised so that they can go to work because they don't have daycare or can pay for someone to take care of their children. So whatever help we are looking for, but we fully support this bill. And Helen, we want to thank you. Sherelle, we want to thank you. Derek, if he's on here, I want to thank y'all for fighting for our members.
Thank you so much.
Thank you so much, Salima. We appreciate you. Are there any other questions or comments from members of the committee? Now, with no further questions or comments being offered from members of the committee, I will ask if there's anyone else present in this hearing whose name we have failed to call and that wishes to offer testimony on any of the bills being considered today. Because we don't want Decker to get us, okay? Okay, we did make that call. Hearing none, we want to thank all of the panels and witnesses for their participation today. We value your opinions. We now want to just make sure that all of the panels and witnesses are disconnected. Lonnie, is everyone else disconnected aside from members of council?
Please give me 1 second.
Sure, thank you.
Madam Chair, we're now ready.
Okay. Excuse me. This concludes the public hearing of the committee. We will now go into a public meeting to consider the action to be taken on the bills before the committee today. The chair recognizes Councilmember Green for a motion on bill number 20076. I'm sorry, we did skip that. Thank you, Rachel. We skipped the roll call. Rachel, will the clerk please call the roll?
Yes. Vice Chair Derek Green.
Present.
Councilmember David O.
Present.
Councilmember Helen Gim.
Present.
Councilmember Curtis Jones Jr., Councilmember Brian O'Neill,
Present.
Councilmember Cindy Bass,
Present.
Councilmember Maria Sanchez,
Present.
Councilmember Mark Squilla,
Present.
Councilmember Green, are you okay with moving the amendments that you have?
Yes,
You
my
have
understanding.
all of the information you need, Councilman Green?
My understanding is that there's an amendment for the resolution for 200216, which is a resolution that goes with 200076.
Give us 1 second, Councilman Green. 1 second, please. Council Lady Gim,
Yes,
do you have all of the information that you need in front of you right now?
I do, Madam Chair. Thank you.
Okay, Councilman Green, if you will, Councilman Green, I want you to stay with me for all of the action from pages 9, 10, 11, 12, 13, to page 13, and Council Lady Gim will move forward on 14. Do you have everything you would need to do that, Councilman Green?
I believe so.
Okay, thank you. The chair recognizes Councilmember Green for a motion on bill number 200076.
Thank you, Madam Chair. I move that bill number 200076 be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council.
Second.
It's been moved and properly seconded that bill number 200076 be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council. All those in favor of the motion will signify by saying aye.
Aye.
Those opposed? The ayes have it and the motion carries. The chair recognizes Councilmember Green for a motion on resolution number 200080.
Thank you, Madam Chair. I move that resolution number 20080 be reported from this committee with a favorable recommendation.
Second.
It's been moved and properly seconded that resolution number 200080 be reported from this committee with a favorable recommendation. All those in favor of the motion will signify by saying aye.
Aye.
Those opposed? The ayes have it, and the motion carries. The chair recognizes Councilmember Green for a motion on Bill number 200208.
Thank you, Madam Chair. I move that Bill number 200208 be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council.
Second.
It's been moved and properly seconded that Bill number 200208 be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council. All those in favor of the motion will signify by saying aye.
Aye.
Those opposed? The ayes have it, and the motion carries. The chair recognizes Councilmember Green for a motion on the amendment to resolution number 200216.
Thank you, Madam Chair. I offer an amendment to resolution number 200216. A copy of the amendment has been circulated to all members of this committee. I move that the amendment to resolution number 200216 be approved.
Second.
It's been moved and properly seconded that the amendment to resolution number 200216 be approved. All those in favor of the motion will signify by saying aye.
Aye.
Those opposed, the ayes have it, and the motion carries. The chair recognizes Councilmember Green for a motion on resolution number 200216 as amended.
Thank you, Madam Chair. I move that resolution number 200216 as amended be reported from this committee with a favorable recommendation.
Second.
The chair recognized for the record that Councilmember O seconds that motion. It has been moved and properly seconded that resolution number 200216 has amended, be reported as amended, be reported from this committee with a favorable recommendation. All those in favor of the motion will signify by saying aye.
Aye.
Those opposed? The ayes have it, and the motion carries.
Aye.
The chair recognizes Councilmember Gim for a motion on the amendment to Bill number 200328.
Thank you, Madam Chair. I offer an amendment to Bill number 200328. A copy of the amendment has been circulated to all members of the committee, and I move that the amendment to Bill number 200328 be approved.
Second.
The chair notes for the record that Councilmember O'Neill seconds the motion. It's been moved and properly seconded that the amendment to Bill number 200328 be approved. All those in favor of the motion will signify by saying aye.
Aye.
Those opposed? The ayes have it, the motion carries, and the amendment to Bill number 200328 has been approved. The chair recognizes Councilmember Gim for a motion to Bill number 200328 as amended.
Thank you, Madam Chair. I move that Bill number 200328 as amended be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council.
Second.
I'm sorry, say that again. Second?
Second.
Okay. I see y'all know Decker is giving me some very specific assignments here. So the chair notes for the record that Councilmember Dom seconds the motion. It has been moved and properly seconded that Bill number 200328 as amended be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council. All those in favor of the motion will signify by saying aye.
Aye.
Those opposed? The ayes have it.
Madam Chair?
Yes.
Yeah, I think for the second on that last matter, I was not Councilmember Dom.
Oh, who was that, Councilmember Green?
Councilmember O.
Councilman O.
That was Councilmember O?
I sound wealthy.
I'm sorry.
Do you feel wealthy?
No, not in this hot room.
Let's let the record reflect that the chair notes for the record that it was Councilmember O that actually seconded the motion to Bill number 200328 as amended. I apologize, Councilmember O.
Oh, no problem. Thank you.
If any bills or resolutions were not considered at the public meeting, we could announce them now. There's not. This concludes the business before the Committee on Law and Government today. And I want to note for the record, Councilwoman Helen Gim, we were actually supposed to be finishing at what time today, Councilwoman Gim?
We were wondering how far past 7 p.m. we were going to get to, Council Majority Leader, but Madam Chair, your leadership on these three major issues around unconstitutional stop and frisk, around a victim advocacy, and around labor protections has been masterful, and I cannot thank you enough.
Madam Chair, I'm going to thank you
Give it
for
to a
allowing me.
woman, and it'll get done on time.
Hey, Councilwoman Sanchez, you need to record that and send it to us so we can play that sometime.
My wife's
Give
in
it to
fact.
a woman if you want to get it done, and the men better stand down.
Madam Chair,
Yes.
I want to thank you for allowing me to reclaim my time, as the great Congresswoman Maxine Waters would say, and enjoy the rest of my evening. So thank you for allowing me to reclaim my time.
All of the men in their new beards can enjoy themselves and have a safe weekend.
Yes, please do, guys. Thank you so very much. It's Friday. Go get something to eat, nourish yourself. And listen, we'll be back on Monday. We'll talk to you all soon. Have a good day.
Take care. Thank you so much.
And some live babies too. See you guys.